All right, y'all. AWB, we back at it. Uh, so for this stream, I want to go ahead and uh, show a channel that I'm actually a fan of, and a channel that I learned a lot from, and that's from the Civil Rights Lawyer. So these are the channels I looked at when I was going out and creating content. These are the channels that I was looking uh, to be more informed about things. So this is actual civil rights lawyer. So the content he had out helped me a lot out with what I was doing. So I want to just start off with, so this is a case that I covered on my channel before, but it's been a while. So in this video, the police showed up and they were saying this guy like beat on his wife or something, and his wife was right there saying no, he didn't do that. But the cops that showed up were so gun ho and just tyranny and just wanted to be egotistical monsters, to where one cop ended up like pretty much beating up the guy who was handcuffed in the back seat. So I'm gonna play that video, and then I'm gonna play the two. It's two depositions of him. So I'm gonna play the video first, and then I'm gonna play the depositions. But I wouldn't call myself a fan of a lot of channels, but this is a channel that I'm a fan of.
On violations of the Fourth Amendment, specifically excessive use of force. When a police officer uses an excessive amount of force on somebody who is just walking down the street, or somebody who's had an encounter with the officer, could be somebody who is being arrested by the officer. If excessive force is used, then the Fourth Amendment can be violated. So I'm going to show you brand new video that's never been seen before on YouTube, showing my client, Melvin Sargent, who had already had force used on him. What had happened is the police had been called to his home by a third party because they heard him having an argument with his wife. And when the police arrived, my client, who had no criminal history whatsoever, had a pistol on him. He was lawfully open carrying, as he's allowed to do in West Virginia. And as soon as he saw that law enforcement was there, he put his hands up and he turned around so that they could see that he had a pistol in a holster on his belt. And it's his allegation that he was then beaten. The video didn't start until the second part of that, when he was already in handcuffs and being placed into the patrol car. And you can see for yourself what happened. And that's the great thing about video. As the U.S. Supreme Court held in Scott versus Harris, video controls if the police officer testimony contradicts what you see in the video. And that might be actually what happens here when you look at what the police report actually said.
Bitch!
You got body cam, I'm gonna sit right there. There you go.
Bitch!
You loosen these motherfucking cuffs out. I'm gonna strip my head.
Why?
Look at this motherfucker, man. I'm serious. Look.
Stop hitting them, bitch! Stop hitting them!
Stop it.
Girl.
Stop.
Girl,
Stop it.
I've known him for years.
Okay, I understand that. But he's got it under control. He has got to stop.
You don't need to hit him in the face.
Stop it.
To get him under control. I
Okay,
know.
when someone comes
I
to you,
can call you a bunch of state troopers if you want.
I don't care.
All right, then I will. Then I will.
We don't care who you call.
Do you know who my stepbrother is?
I don't care.
No, you don't. Because he got killed.
Come on.
He got killed on 77.
Hey, boy, you need to
Baby.
get in. Look at me.
Bitch, quit. Bitch, no. Bitch, please.
Listen.
Don't hit him like that.
Whenever listen. When I tell him to put his hands on his hand,
I understand.
and he goes to grab his back, I'm going to protect me, he and
I'm
her,
sorry.
or him.
I know.
They're going to get your info. I'm taking him to the office.
Well, I know you both, so you know my info. You both know my info.
I know. She's going to get your info.
I'm sorry. Man,
All right, let's take a look at slow motion, the use of force that's captured on the video here. You see that my client's handcuffed. He is not assaulting the officer in any way. And then all of a sudden, boom, the deputy pushes him into the patrol car. He's still handcuffed. And you'll see that the officer then lunges in after him, and his body jerks around just like he's punching him. You can see that the client here, he's handcuffed, and there is when the push begins. And there's his glove afterwards. That's one of those weaponized Oakley gloves, I believe, and it's got my client's blood on it, right on the knuckles. And look at all the blood stains on my client's pants after he got out of jail and went to the hospital. And that's his hand that was broken because it was stomped. So let's take another look at how we got those pictures of the bloody gloves. And that's when Deputy Bish, who was the guy who had used the force against my client, walked back over to my client's wife, who was filming him, and they knew each other from the past. And he's explaining why he did what he did to her. And you can see the whole time the bloody knuckles, which he probably didn't even realize at the time were there.
Okay.
and she don't even touch me like that, bitch. You know who my brother-in-law is.
She don't know you.
But you know who my brother-in-law is.
But here's the thing. She's going to...
He's an Interstate 77 guy that got killed last year.
Simon, I'm not listening to anything you say.
I got it.
I'm not listening.
I got it. But I know them too, and I'm a good person, and I do a lot of good things
I
with you.
understand that, but when he's fighting and that's going on, I'm really not listening. Hey, I'm trying to get you back.
Is that my gun? That's my gun.
This is yours?
Yes, it's registered to me. You can go run it. That's mine. No, bitch, no. Run it, please. It's in my name, I swear. Run it.
You're going to get it back.
No. That's my fucking gun, though.
Joey,
really?
Get her info.
So, girl, no, they know my info. Don't you come near me.
Come on.
Bitch, no. Really?
And this is where the video takes really a bizarre turn, where another deputy who wasn't involved in that use of force walks up to my client's wife who's filming and actually puts his hands around the wife's throat and decides to give her an instruction on respecting the authority and respecting the badge. Apparently, the wife knew this deputy before he became a male deputy, and when he was then a female deputy, they apparently knew each other.
All right.
I need
What,
to
Heather?
see.
Do you see this fucking badge on her
Yes,
chest?
I do, Heather.
Do you know what that means? You
Yes,
respect
Heather.
it.
Yes.
You respect
Please
me.
don't touch
Listen,
me.
you respect me. All right? I'm
We're just trying to get an update if you guys just need EMS for either deputies or the
I'm
other
not
person.
trying to get your attention because you're looking over
They
here.
take so no take pepper spray used this time. Kick them out
You
with
respect me. You respect her. You hear
Yeah,
me?
be
You've
kicking
been
windows
drinking.
pepper spray
A
used
little.
this
Then I
time.
suggest you stop.
Okay, I
You feel
stopped.
me?
Yeah, I feel you. Hey, Derek, I'm sorry.
When we're talking.
I get it. Okay, I get it. I'm sorry.
Get ready. What's your name and birthday? What's your name?
Sorry. I guess arrest me next.
Apparently, at about the time that my client's wife was getting lectured about respecting the badge, the client is in the back of the car handcuffed, and he sees this happening with the deputy's hands going around her throat, and he starts to really freak out and scream or get upset. And then the same deputy who had used the force on him apparently opens the door and sprays him with pepper spray, then closes the car door. And then now in this next clip, as his wife is trying to get her gun back that had been seized, you can hear my client in the background from inside the police car crying about his eyes.
When can I get it? Tomorrow after you talk to us? How much you think? Where's it gonna be?
It's going to be the judge.
Where's it gonna be at?
After I get him back to office call. Okay.
Just let me breathe.
Let me get him to the office and you can call. Okay.
All right.
That's pretty much all the video shows. So there was apparently another use of force on the way to take him for processing. They had stopped the car and apparently used force on him again, even though he was handcuffed in the back of the car. But at least we have a portion of this that was caught on video. Now, after he was arrested, he ended up bonding out later and was taken immediately to the hospital by his wife. And they documented that he did have, these abrasions still on his body, and including a fractured hand from where the same deputy who used force on him actually stomped his hands. And that's why my client was asking and really begging this deputy to loosen the handcuffs when he was getting put into the car. And that's why he was sort of turning around, showing him the handcuffs, because his hand had been stomped by the deputy and it was broken and it was starting to swell and was really hurting. And we have photographs of his hands where the swelling had really caused these abrasions on the handcuffs after they were put on. Here are the charges that he was charged with: 2 counts of obstructing an officer and 2 counts of battery on an officer. And here is the actual police report that was included in the criminal narrative for the charges. And you ask yourself if you see this in the video. All right. At this point, Deputy Calloway arrived on the scene, began to assist. We were able to stand Mr. Sargent on his feet as he continued to refuse to comply. We were able to secure him in the rear of my cruiser. After closing the passenger side rear door, Mr. Sargent began to kick the inside of my door, causing the door to begin to bow out. At this point, I opened the same door. It began to yell, tell Mr. Sargent to calm down and stop kicking the door, or we would spray him with OC. At this point, he leaned back and kicked towards me, striking me in the chest. At this point, I administered a short 3 to 5 second burst of pepper spray in Mr. Sargent's eyes. At this point, it appeared as Mr. Sargent had finished. Did you see that on the video? No, I didn't either, even in the parts you didn't see. Here's the ultimate plea agreement that resolved the case, is that 1 count of obstruction was dropped. He pled guilty to the other count of obstructing an officer, and both counts of battery on an officer were dropped by the prosecutor's office. And that is a really telling fact. Now that the criminal case was resolved, we can go ahead and proceed with the civil side of things. Like I said, this is basic Fourth Amendment excessive force law under the Graham factors. And I believe that just based on what you see on the video, that will be a strong enough case to get to a jury. Now, what a jury does with it is always a roll of the dice, and we'll just have to see. So stay tuned.
All right, y'all. So I'm gonna get ready to go ahead and just play the first part 1 of the deposition. But as you can see, this made no sense. The wife already said everything was okay. So he's putting him in the back of a police car based on a 911 call, but not made by the wife, made by somebody who was just around the area or something. And without any investigation or anything, look how he's being treated. And you got to remember, it was no investigation of nothing. Oh, they said, something might be going on with him and his wife. And you approach him and his wife is there and she's wondering, why are you attacking him like this? And that should tell you everything right now. Or you could just ask her questions. But no questions were asked. He gets his hand broken, stomped on, broken. He got pepper sprayed, and they're just, it's crazy how they're treating him for no reason. Absolutely no reason. The wife is there. All they had to do was just ask the wife, what happened? What's going on? But no, they didn't do that. But they are quick to pepper spray him and break his hands, stomp his hand out and break his hand, and throw him in the back seat and arrest him and take him to jail for absolutely nothing. So we're gonna play part 1 of the deposition right here.
Basically, half of that ended up being filmed by my client's wife. So fast forward to the federal lawsuit being filed, and I'll link the original video here in the description so you can review that first. Now you get to see, this just happened last week where I took the depositions of the police officers who were involved in that incident, got to put them under oath and ask them questions. So here's something really you rarely get to see. And I'm curious, I cut it up a little bit. This will have to be part one because it's long. I'm curious to see what you think. So you saw the video and you can actually read the lawsuit allegations. Now you actually get to see the evidence. Take a look. Really curious to know what you think.
This is the video deposition of Joshua Bish being taken by the plaintiff, Civil Action 121 CV 615, captioned Melvin Sargent v. Joshua Bish et al., U.S. District Court for the Southern District of West Virginia at Bluefield.
Do you remember why you were initially called to this scene?
I was advised by Mercer 911 that there was a ongoing domestic between Melvin Sargent and another female, where Melvin Sargent had apparently was arguing and physical and was trying to kick down a door.
And do you remember who had called 911?
Off the top of my head, no.
Did you know at the time?
No. All we received was the name of the individual that was possibly causing the problems. And
had you ever been to that location before?
no, I have not.
Were you familiar with that location at all?
No.
Did you know who lived there?
No.
As of that moment, did you know who Melvin Sargent was?
No.
Okay. When you pulled up to the scene on November 28th, tell me about it. What did you see upon your initial arrival?
When I pulled in, I observed a female a few car lengths away, walking away, and observed Mr. Sargent, the male individual that was described to be Melvin Sargent, walking from the road in the yard, going towards the basement door of the residence. At that point, I observed the male. He was kind of walking with his fist clenched, kind of looked irritated, and the female was obviously upset, crying. And because Moore hadn't been certified and hadn't dealt with any, I didn't feel comfortable with her approaching anybody that may have been aggressive of any way. I told her to go talk to the female, and I went to go talk to Mr. Sargent. It was one of those real quick, hey, you go talk to her, I'm gonna go talk to him.
Let me refer you to your police report. Again, you wrote that report, right?
Correct.
You were aware of the fact that you needed to include all important details in your report.
Correct.
Okay. And you believe that you did that?
I believe I did, yes.
Okay. You wrote that Deputy Adair later advised you that Mr. Sargent and her were talking about Mr. Sargent's deceased mother, at which point her mother came into the room that they were in and rolled her eyes about the conversation, which aggravated Mr. Sargent, causing them to argue. She advised prior to law enforcement arrival, there was no violence and nothing is wrong.
Yes.
Is that your understanding?
That's my understanding.
Now, you told me you didn't know who the 911 caller was.
Correct.
Did you ever talk to the 911 caller before arresting Melvin Sargent that day?
No.
Did you ever even find out the name of the 911 caller prior to arresting Melvin Sargent?
I think I remember asking them, but I don't ask them, daring them to get all the information, but that was about it.
But you never talked to the 911 caller?
No, I did not.
Did you talk to Jolena Chavez prior to arresting Melvin Sargent?
Prior to arresting, no.
But prior to arresting him, you had not talked to any witnesses, correct?
No, correct.
Prior to arresting him, you hadn't even talked to the plaintiff about what had happened or what had not happened?
Correct.
Now, what about Melvin Sargent? Did you know who he was?
I just gathered from the description 911 gave and his mannerism, how he was walking, and he was obviously upset and irritated. And I wanted to talk to him first, considering he was because how he was walking and carrying himself, felt he was more of possibly the possible suspect that 911 had described, and figured go ahead and talk to him before he gets too far away and I have to run.
So where was he located physically when you first saw him?
Whenever I first pulled in, he was to my 3 o'clock in the driveway, maybe from here to the second pew.
So he was located in the driveway to this residence?
Correct. And walking away from me towards the basement door.
And did you say anything to him initially?
I did. I asked him, hey, stop right there for a minute.
Did he say anything to you?
No, he acted like he didn't hear me, which I gave benefit of the doubt that just pulled in. Woman down the street was screaming pretty loud and crying, and my car was running. So I went around to the front of the car, kind of faster pace. Hey, bud, stop right there. And he complied.
Did you, upon your arrival, did you personally observe any crime being committed by anybody?
Upon my arrival, no.
It didn't appear to you that Melvin Sargent was threatening her in any way, did it?
I didn't see any type of threats at that point. No, he was walking away from her.
You didn't see any domestic violence, anything like that?
No.
Did you know at the time who lived at that house?
No, I did not.
Did you assume that these two individuals lived at that house?
I'd imagine that they was the ones that was living there.
Did you identify yourself to him?
Yes.
What'd you say?
Like I did with any time I approached anybody, I'm Deputy Bish with the Sheriff's Department.
And did you tell him why you were there?
I was getting ready to, hey, I need you to stop right there. He stopped, and I said, before here over some type of fight or something, I don't know what else is going on, but before we go any farther, I need to pat you down and make sure there's no weapons or anything that can hurt me or you.
All right. So at the time this interaction took place, you're both standing in the driveway.
Correct. Close to the basement door.
And you had not at that point talked to Juliana Chavez.
Correct.
You had no idea what she had to say.
Correct.
You had not observed any crime being committed as of yet, have you?
Correct.
In fact, you didn't have probable cause at that point to believe that any crime had been committed.
I had
Sorry, you can answer.
I had reasonable suspicion that there was something that had happened.
You got a domestic call.
Yes.
You had reasonable suspicion to show up to that call.
Yes.
Now, you know what probable cause is.
Correct.
You would agree with me that at the point you first encountered Melvin Sargent, you didn't yet have any probable cause to believe that he had committed a crime.
Correct. All I had was reasonable.
So when you first encountered him, he wasn't under arrest at that point.
No.
Was he a suspect?
No. He was an individual in the scene of the call that would fit the description of what was described.
So he wasn't even a suspect of any particular crime at that point.
Correct.
When this first initial encounter between you and Mr. Sargent took place, did he attempt to flee or evade you?
No.
So when you told him to stop, he stopped?
After the second time. But I gave him the benefit of the doubt because of the circumstances.
And then what happened?
He turned around, looked at me, told him, hey, my name's Deputy Bish, Sheriff's Department. You just stop. We're here over some type of fight. And prior we go any farther, I'm going to make sure you don't have any weapons or anything that can hurt me or you, so we can figure out what's going on. He ended up putting his left hand kind of towards me, and like this, and he started to move his right hand behind his back.
And at this point, you don't have an arrest warrant, right?
No.
You don't have a search warrant for the residence?
No.
So did Melvin turn around and face you?
He did.
You asked Melvin at that time for ID?
No.
Did you ask him what his name was?
No. My main goal at first is to make the scene safe.
Did you have any indications that the scene was not safe?
From how he was walking and his nature of how he was looking, felt that there may be something to it.
And you said that was the fact that he had clenched fists.
Clenched fists, how he was walking, and just his overall mannerisms. And
how would you describe this walk?
Tense, like his muscles were tensed.
Were you wearing a body cam?
No, I was not.
And did Melvin say anything to you at this point?
No.
So at that point, were you detaining Melvin?
At that point, I was approaching to conduct the safety check to ensure the scene was safe and begin to ask my questions for why are we here?
Well, I mean, was he free to leave and go in the house at that point?
At that point, no.
So you were conducting a safety check and he was being detained, had to comply with that safety check?
Yes.
Did you ever ask Melvin Sargent or any other homeowner or any other resident at that time, or someone you thought was a resident, for permission to be on the property?
No.
I assume nobody gave you permission to be on the property.
Nobody told me I couldn't.
Did Melvin give you any indications that he didn't want you on the property?
No.
You wrote in your report that at first Melvin began to comply.
Yes.
You told him to stop and he stopped.
Yes, he stopped, turned around, faced me, put his left hand up and started reaching behind his back with his right.
Didn't you ask him to put his hands on his head?
No.
You didn't?
No, I asked him to stop right there and I'm just going to pat you down real fast.
You didn't write in your report that you asked Melvin to put his hands on top of his head?
No.
All right. I asked you if you asked Melvin Sargent to put his hands on top of his head, and your recollection is that you had not.
No.
But reviewing the report that you wrote after this incident, your report indicates that you did.
Yes.
Which is it?
It would be what's on the report.
All right. You wrote in your report, as I approached, I observed Mr. Sargent had his right hand in his right front pocket and his left hand on his side.
Yes.
I told Mr. Sargent to place his hands on top of his head, that I was going to conduct a safety check to ensure he did not have any weapons.
Correct.
When you asked Mr. Sargent to put his hands on top of his head, what did he do?
He put his left hand out in front of him and started to reach behind his back with his right.
And you didn't know who he was, right?
No.
All right. So then what did you do?
When his hand went up, and then I seen his right hand going behind his back, with my left hand, I reached around on his wrist to do a come-along hold with a simple wrist maneuver to gain compliance, because I didn't know what he was reaching for, and I'm not taking any type of chances to risk myself or himself or anybody else's safety.
And why specifically his right hand? Why'd you grab his right hand?
I grabbed his left, I'm sorry, as he was facing me.
All right. Well, you wrote in your report that you grabbed his right hand. All right. I believe if you look at third paragraph, you say, I told Mr. Sargent to place his hands on top of his head, that I was going to conduct a safety check to ensure he did not have any weapons. At this point, Mr. Sargent began to comply, at which point I stepped towards him and began to reach for his right hand, at which point he started to step away.
Yes.
All right. So initially you went to reach for his right hand.
Yes, that was the one that was moving, but it was on his opposite side, and his left hand was right there in front of me.
All right. Why did you begin to reach initially for his right hand?
I didn't know what he was reaching for.
Okay. It wasn't because you were going to handcuff him?
No.
Because he wasn't under arrest at that point.
No. At that point, if we could play a whole what if game all day with it, but if he would have just let me pat him down and found out nothing would have been wrong, would have been on our way.
He hadn't threatened you?
No.
He hadn't attempted to strike you?
No.
So what happened next?
When I was able to grab his wrist, he attempted to pull away very aggressively, and considering he was still trying to reach behind his back and then complying with me from telling him to stop, I ended up striking him with a closed fist to the right cheek, or left cheek, I'm sorry. I ended up striking him in the left side of his cheek. We began to spin around and wrestle around a bit till my back was to the house, and he ended up getting pressed up against a car door, a car that was in the driveway. I was able to get him spun around. At this point, Deputy Moore had came down, assisted with the wrestling match for a moment, and we both observed that there was a firearm in the small of his back. Deputy Moore secured that, was able to pull that weapon out and went to go secure it, at which point I was able to manipulate his arm a little bit more to where I was able to put him onto the ground. He ended up rolling onto his back, and we continued to wrestle. At that point, he was, in my eyes, he was under arrest. And it was pretty much just a big old wrestling match until Deputy Moore got back after securing the weapon somewhere. And we was able to get him rolled over on his stomach and handcuffed.
Right, but you didn't have any information or indication that he was armed at that point?
I didn't know.
So you hadn't seen the gun yet?
Correct.
Okay, so you're just treating him like anyone you're encountering, they theoretically could be armed?
Yes, anybody can be armed with anything, and my goal is I want them and me to go home at the end of the day.
But nobody had told you that he was armed?
Correct.
And he hadn't told you that he was armed?
No.
You hadn't seen a gun?
No.
So you hadn't run his criminal history or anything like that?
No.
So at this point,
we're still in the driveway, but because we're moving, it's the doors. I'm not sure where the basement door was.
He doesn't want to have this interaction with you?
Correct.
So was he under arrest at that point?
At that point, as soon as he refused to allow for a safety pat down, he was under arrest for the obstructing.
So did you ever go to the ground with him?
After the firearm was secured. Me and Melvin ended up going to the ground, continued to wrestle. When Moore got back down there, he kicked her in the chest, after which point I again struck him with a closed fist, trying to gain compliance. And eventually we was able to get him rolled over and handcuffed.
Melvin Sargent had never grabbed a gun.
No, he never actually touched it.
And what happened after you punched him in the face?
He lost balance a little bit, and that's when I was able to maneuver to where I was facing his back to get him.
All right, what happened after you got him to the ground?
We wrestled, trying to get him to roll over using empty hand control, wrist manipulation to get him to roll over.
Did you strike him again?
I don't remember. I'm pretty sure I did, but I don't technically remember.
Now, Melvin alleges that at some point during this time period that you stomped his hand or his wrist. Do you deny that?
Yeah, I never stomped anything.
Do you have any idea what could have injured his wrist or his hand during this encounter?
During this encounter, nothing. It could have been from before we got there, him hitting something, or had something happen at the jail out.
But you did punch him in the face?
Yes.
You never were aware of any injury to Melvin's wrist?
No.
Now, when you punched Melvin, were you wearing gloves?
I was.
Tell me about your gloves.
They're a cloth mixed with a type of UFC type knuckle covering to protect my knuckles and anything I come in contact with.
All right, I'm going to show you what's been previously marked as exhibit number 5 for this deposition.
Yes.
Now, I'll represent to you that that is a screenshot that I took out of the video that we have in this case. Does that screenshot accurately represent your hand and your glove on the date of this incident?
It does.
I'll also show you what's been marked as exhibit number 6. I know this isn't the greatest quality, but that is a close-up of your glove, also from the same video.
It is.
Would you agree with that?
Yes.
It's your testimony that these gloves, they have reinforced knuckles.
I wouldn't say they're reinforced. You know, the UFC type gloves that has like a little padding. That's all it is. It's a thing. It's just, I broke my hand a few times, so I wear it so I don't do it again. And
you broke your hand a few times punching people?
Yes, it was in a fight.
While you were working as a police officer?
Yes.
Okay, so as a result of that, you bought these gloves?
Yes.
They have extra material at the knuckles?
They do. It's a padding type thing.
So that's to protect your knuckles when you're punching people?
It protects my knuckles, and if I make contact with another individual, it protects them from any type of like knuckle cut or anything.
So you're saying that when you punch somebody with that, it's actually going to feel better to them because you have that glove?
It should, yeah. Feels just like one of the UFC gloves, like little makeshift boxing gloves you wear when you're sparring.
Yeah, I mean, I've seen the UFC gloves,
yes.
and those are not UFC gloves.
No, they're not UFC, but that's what the padding feels like.
I mean, they'd have some problems in UFC if they use those gloves.
Okay. I'm just saying the gloves are that's what the padding feels like.
Do you still have the gloves?
I do not.
Why not?
When they got blood on them, I threw them away. I don't take anything that gets blood on back home to my house.
Did you buy another pair?
I did.
Do you still have it?
Those ones, no.
Now, those were not issue gloves.
Correct.
So that was just your private purchase.
Yes.
Did you get any sort of authorization from your employer to buy or wear those gloves?
I got them from, at the time when I bought them, Chief Deputy Bailey. I showed them to him. He said they were perfectly fine.
At any point, did your employer instruct you to no longer wear those gloves?
No.
But since you left the Mercer County Sheriff's Office, you've never worn them again?
No, because the policy down there is
what?
They don't allow any type of gloves.
I mean, in your job now, you don't find the occasion to punch people?
I probably will, but I haven't yet.
You said you threw those gloves away because they had blood on them, right?
Correct.
And that blood was Melvin Sargent's blood?
Not sure.
Well, they didn't have blood. The knuckles of your gloves did not have blood on them already on your first arrival at Melvin Sargent's house.
Correct. My mouth was bleeding as well.
All right. Well, you punched Melvin Sargent, you said, in the face.
Yes, in the cheek.
Right, and he was bleeding.
I'm not 100% sure if he was or wasn't. I didn't notice any cuts or.
All right, so you have no idea if that's Melvin Sargent's blood.
Correct.
So you're saying it could be your own blood
It could be.
on your knuckles.
Yes.
You didn't punch yourself, right?
No, I did not.
You punched Melvin Sargent.
Correct.
And it's your testimony here today under oath that you don't know whether or not he was bleeding.
Correct. I'm not 100%. No.
He was treated subsequently for lacerations inside his mouth. You have no idea how that could have occurred.
Inside of his mouth? No, I have no idea.
That's not from you punching him in the face.
It could. I don't know.
You have no explanation for that?
No.
Did you ever see Melvin Sargent punch himself?
No.
Did you ever see him slam his head into your police cruiser or anything like that?
I know he kicked and thrashed around in the backseat of the cruiser quite a bit, but I never seen him physically punch himself.
You're not alleging that he injured himself.
Oh, no.
Whatever side it was,
Yeah.
other than the one punch to Melvin's face that you already testified about, did you ever strike him in the face again during this incident?
Yeah, while he was on the ground wrestling, after he had kicked Deputy Moore, causing her to fall backwards.
Is this before he was handcuffed?
Yes.
Okay. And how many additional times did you strike Melvin?
Just the two total, the one initial and the one on the ground. I didn't want to throw any more punches because I was afraid if I would, where I was on top of him and he was on the ground, his head would have bounced off the ground or something, caused undue harm. I didn't want to do that.
So to the best of your recollection, it's your testimony that you punched Melvin twice that day.
Yes.
And are you positive that you didn't punch him any more times?
Correct.
Were your emotion levels up at this point?
No.
Were you angry?
Just fat and out of breath.
Then what'd you do?
We both stood up for maybe 5-10 seconds so we can collect me personally could collect my breath. And like I said, I just got done eating Thanksgiving dinner and I didn't want to throw up on the poor dude. And we collected ourselves and we was able to get him to stand up and walk him up towards my cruiser.
So you guys got him up and you put him in the police car, is that right?
Walked him up to the driveway and on the passenger side of my cruiser.
And then did you put him in the car?
Yeah, I put him in the seat, sat him down. His feet was still outside the cruiser. He refused to put his feet back into the cruiser. I told him multiple times to do it. He complained that his handcuffs was too tight. But prior to that, whenever he was handcuffed, it was with Deputy Moore's handcuffs, and I'd been training her, and I observed her do the pinky tight, which is where you can slide your whole finger inside the cuffs.
Who put the cuffs on?
She did.
All right. It's my understanding from reading your report that you guys put him in the back of the police cruiser and shut the door initially.
No.
No?
Not initially, no.
Take a look at the report. Let's see if we can clear this up. Okay, the next sentence you wrote in your report, after closing the passenger rear side door, Mr. Sargent began to kick the inside of my door, causing the door to begin to bow out.
Correct.
All right, that seems to imply to me, or to tell me, that you had closed the passenger rear side door.
When we first got to up there, he refused to get in and ended up having to force him into the vehicle to get his legs all the way in before we could shut it.
The point is you put him in the car and you closed the door.
After I had to force him in, yes.
All right, so you forced him in the rear passenger door and closed the rear passenger door.
Yes.
So he's inside the rear of the police cruiser.
Yes.
The door is closed.
Yes.
He's handcuffed.
Yes.
Behind his back.
Yes.
Then what happened?
I went to the opposite side to where his head was, opened the door, pulled out my OC spray, and advised him if he did not stop trying to kick the door, break the window, he would be pepper sprayed.
So you had the door closed, and then you opened that same door.
Opposite door.
All right. Are you sure it's the opposite door?
Yes, because his head was toward, I wasn't going to go down where he was kicking at.
All right. You wrote in your report, at this point, I opened the same door. Began to tell Mr. Sargent to calm down and stop kicking the door, or he would be sprayed with OC.
I'm going to go with that's going to be a typo. No.
All right. So you're saying your report is wrong.
On that sentence.
Why would you have written the same door in your report?
Considering this narrative was written quite a few hours later, and tired, wanting to go home. Rushed it. It is a mistake.
Would it be fair to say that even a few hours after the incident, that your memory about the incident would have been more accurate in 2019 than it is here today in August of 2022?
My recollection, it's still pretty similar to it.
All right, so he's handcuffed behind his back, he's in the rear of the cruiser, he's kicking the inside of the door. You then you say the driver's side passenger door, right?
Yes.
And then you do what?
Tell him if he doesn't stop, he will be pepper sprayed.
And then what happened?
He says, fucking do it, and started kicking the door again.
And then what happened?
Administered a short 3 to 5 second burst of OC spray.
So you sprayed him with pepper spray for 3 to 5 seconds?
Yes, which is what we were taught.
Did you strike him at all?
No.
So at this point, you still hadn't talked to any witnesses?
No.
You closed him inside the rear of the police cruiser with pepper spray in his eyes?
It was, yes.
Were the windows rolled up?
It was cracked.
Cracked how long? How far?
I'd say enough to where if somebody had free hands, they'd be able to put their fingers through the tops of both.
And did it appear to you that Melvin was suffering from the pepper spray at that point?
He was in pain from it, but it was nothing that I hadn't seen or felt myself before.
But you didn't strike him at all in the rear of the police cruiser?
I did not strike, no.
Did Melvin attempt to strike you?
In the back of the cruiser, no. He attempted to spit.
All right. You didn't write anything in your report about him attempting to spit on you at any point, did you?
No.
But you did write in your report an allegation that Melvin had leaned back and kicked towards you, striking you in the chest.
Yes, this was after, if I'm thinking right, and whenever we had to stop because he started to kick the door again as we was traveling.
All right. So you're saying that happened during the transport?
Yes.
Right. I don't think that exactly jives with your report. If you want to take a look at it,
So I just say it looks like I probably just forgot where I was in the narrative when I was typing and posed them on separate sides. Looks like that one goes to the other paragraph.
Reading your report, yes, you would agree with me that it says that this encounter took place before you left the scene.
Correct.
Because you described what happened, the allegations that you're trying to get him to calm down and stop kicking the door, and that that he tried to kick you, and that you sprayed him with pepper spray. And then you described Deputy Adair arrives on the scene with Trooper Russ.
Yes.
So the way you wrote the report, it sounds like this all happened at the scene before you left to transport Mr. Sargent.
Yes.
But you're telling me today that your testimony, that your report is inaccurate. Is that right?
That section, yes.
All right, I'm going to show you what has already been marked as exhibit number 2 for this deposition. Now, that is the criminal complaint that charged Melvin Sargent in this case.
Yes.
And that criminal complaint includes a narrative written by you, correct?
Yes, the same narrative.
And that's the same narrative, the same police report that we've been discussing.
Yes.
You included this same report written in the same way to the magistrate, I think it was Magistrate Dorsey, to review.
Yes.
And the magistrate did review this report, and it actually indicates that probable cause was found for the warrantless arrest of Melvin Sargent that day.
Yes.
Okay. And then Melvin Sargent was prosecuted pursuant to this criminal complaint.
Correct.
Okay. Would you agree with me that the report that you submitted to the magistrate as part of this criminal complaint was under oath?
Yes.
Okay. So you're telling me here today that there are these inaccuracies in your report, but you never informed the magistrate that there were inaccuracies in your report, did you?
I didn't notice them.
So you didn't notice the inaccuracies in your report until today, August of 2022?
Yes.
Okay, so he had been charged with 2 counts of battery on an officer, right?
Yes.
And then 1 count of obstruction.
Yes.
Now, I take it the obstruction, I think you already testified, the obstruction was when you initially encountered him and tried to perform that safety check,
Yes.
he didn't initially, or he began to comply, but then pulled away.
Pulled away, yes. And
That was the obstruction.
that's the obstruction.
But you also had him charged using your report with 2 counts of battery on an officer.
Correct. Whenever he kicked more and I got hit sometime. I don't know when it was.
Well, you wrote in your report that he had tried to kick you in the chest,
Yes.
but your report says that happened at the scene.
Yes.
You're telling me now that happened during transport.
I believe so, yes. That's what's making sense.
All right. I mean, you understand that you're under oath here today.
I do, yes.
All right. I'm not asking you to guess, and I don't want you to guess if you don't remember.
Okay.
Okay. Do you remember whether or not the allegation of Melvin trying to kick you happened before you transported Melvin or during the transport?
That was during the transport.
You're positive,
Yes.
but that's not what's represented in your report.
Correct.
Objection. Asked and answered.
All right, I'll show you what's been marked as exhibit number 3, and that is a court order or a motion form indicating that the 2 charges of battery on an officer were dismissed by the court.
Correct.
Melvin Sargent was not convicted of those allegations or of those charges, was he?
Of the batteries, no.
All right, I'm going to show you the video that we have in this case.
I can see it. Careful. Stay there. Stay there.
Stop, bitch!
You lost me, motherfucker.
Why? Stop hitting them, bitch! Stop hitting them!
Stop.
Girl,
Stop it.
I've done it for years.
Okay, I understand that. But he's got under control. He has got to
You
stop.
don't need to hit him in the face.
Stop it.
To get him under control. I know.
When someone comes
I can call you a bunch of state troopers if you want.
All right, so that was 0 through about 32 seconds of that video.
Correct.
That shows you in the video, right?
Yes.
And you're placing Melvin Sargent in the rear of that police cruiser.
Correct.
You saw and you heard Melvin Sargent asking you to loosen his handcuffs.
Yes.
That section of the video, would you agree with me that it shows you engaging in a use of force against Melvin Sargent?
It does.
Would you also agree with me that that section of footage, 0 through 32 seconds, does not show Melvin Sargent kicking you in the chest?
Correct.
It does not show Melvin striking you in any way?
Correct.
What would you characterize as the nature of the force that you used? What did you do?
The push in, and while he was inside the vehicle, I held his head down with my right hand because he kept trying to come up, trying to spit on me.
Okay. And again, your report mentions nothing about Melvin trying to spit on you.
Correct.
So are you saying that you didn't strike him at all?
I never hit him in the back of the cruiser, no.
What we see in the first 30 seconds of this video, you're saying that no punches were thrown by you.
No, no.
You're just holding him down.
Yes. Holding him down, trying to talk to him, tell him calm down, quit. As soon as we get to the office, we'll figure everything out.
All right. So looking at your report again, the use of force that you did engage in at this point, in the first 30 seconds of the video, you didn't mention anything about that in your report.
No.
Melvin Sargent was handcuffed at this time.
Yes.
All right, let's continue to watch the video. We're at 32 seconds. I'm going to play it a little longer.
Bitch, quit. Bitch, no. Bitch, please. No.
All right, so I stopped at 55 seconds there. From the 30-second range to the 53-second range, would you agree with me that shows additional uses of force by you against Melvin Sargent?
From forcing him into the vehicle.
You tell me.
Yeah, from forcing him into the vehicle, and that was it. From holding his head down and me getting out and using vocal commands.
All right, did you use physical force on Melvin Sargent at this time?
Define physical force.
All right, let's play it again. From 30 seconds. This time we won't stop it.
Okay.
So that was part 1. Well, let's call that part 1. And as you can see, I'm dressed like I've been in court, and I have been in jury trial for the past 2 days. So I'm pretty exhausted. This is all I've gone through so far. But you're going to want to see part 2 because if I recall correctly, and it was just last week, it gets even better. And the other police officers involved took their depositions as well. So you will want to see part 2.
Yeah. All right, y'all. So we're gonna jump into part 2. But I just wanted to say a few things about this part 1. Well, he ran up on him and stopped him and tried to force him to give up his rights, all because he was walking suspiciously or a way that he didn't think he should be walking, or his whole approach to even stopping him. And I wouldn't even say stopping him because all he did was just try to violate him. He didn't stop it. He didn't pull him over. He just saw somebody outside and just told them to give up their rights. And as soon as they didn't give up their rights right away like he wanted, he broke this man's hand and then pepper sprayed him. Can you imagine that? They broke his hand, pepper sprayed him, and took him to jail. All because somebody didn't just give up their rights the way he wanted them to. He already said the man complied with everything he was saying. And like, this made absolutely no sense. And that's why I say this man is a sicko. He is a psycho sicko. Something is very wrong with him. I can't believe he's still in a badge. And they keep giving badges to people like this. It makes no sense. Why do you keep hiring people like this and letting people like this continue on? It's just insane. So he tried to charge him with obstruction based on absolutely nothing. He wasn't obstructing anything because he wasn't under arrest at all. He wasn't under arrest. It doesn't even sound like you were doing any type of investigation. So what was he obstructing? He's saying obstruction is this guy not giving up his rights to the way he wanted him to. And because he saw a guy put his arm on his back or whatever, he just flipped out and grabbed his arm, threw him on the ground, broke his hand, and then pepper sprayed him later because the man was in the back of the car, basically upset that he's been violated so much for absolutely no reason. And this cop has padded gloves because he knows he likes to beat on people, that's sick enough. The fact that he has padded gloves. He's talking about, it's to protect me and them. Like, it makes absolutely no sense. How crazy is this to y'all, man? So he broke his hand, pepper sprayed him, punched him in the face, all based on nothing. All based on you saw him walking suspiciously. Think about how insane this is. No crime, no nothing. No laws broken. You saying you assume that he's the suspect because the suspect of whatever the call may be, you didn't even say what you suspect him of doing because the call wasn't based on anything. The call was based on a couple having an argument, I guess. And he gets there and he acts like that, which is so crazy. But let's go ahead and get into part 2.
Welcome. I know a lot of you enjoyed watching part 1 of the officer depositions in the Sargent versus Bish case. So this is part 2. If you haven't seen part 1, I'll put the link in the description. You have to watch that first. So this continues. This is part 2 and the final bit of deposition for this particular officer. In part 3, we'll get into the other officers. The use of force that you did engage in at this point, the first 30 seconds of the video, you didn't mention anything about that in your report.
No.
Melvin Sargent was handcuffed at this time.
Yes.
All right, let's continue to watch the video. We're at 32 seconds. I'm going to play it a little longer.
All right, then I will. Then I will. You don't care who you call. Do you know who you know what there is? I don't care. No, you don't. That thing got killed. Come on. Thing got killed on 37.
Yeah, look at me.
Bitch, quit. Bitch, no. Bitch, please.
You're winded. That's where he kicked.
Can we play it again? Yeah. Play it from 27 seconds and we'll play it to about 53 seconds.
Get him under control. I know. When someone comes, I can call you a bunch of snake troopers if you want. I don't care. All right, then I will. Then I will.
Okay.
You don't care who you call. Do you know who?
All right, so you're saying you saw a kick?
Yes.
All right, then I will. Then I will. You don't care who you call. Do you know who?
See his leg coming back down.
I don't care. No.
All right, you're saying you saw a kick somewhere in the 30-second range?
Yes.
So now you're saying that Melvin did try to kick you?
It appears so, yes.
Okay, but he didn't kick you?
I don't remember it right there.
Let me continue playing it, and then
Okay.
I'll ask you some questions.
That thing got killed. Come on. They got killed on 37.
Boy, you need a baby. Yeah, look at me.
Bitch, quit. Bitch, no. Bitch, please.
From the 30-second range to the 53-second range, would you agree with me that shows additional uses of force by you against Melvin Sargent?
From forcing him into the vehicle?
You tell me.
Yeah, from forcing him into the vehicle, and that was it. From holding his head down and me getting out and using vocal commands.
All right, did you use physical force on Melvin Sargent at this time?
Define physical force.
All right, let's play it again. 30 seconds. This time we won't stop it.
Okay.
All right, so watching that video, it looks like your feet are outside the police cruiser and the upper half of your body is leaning inside the police cruiser with Melvin.
Yes.
And it looks to me like your body movements are jerking in such a way as is there's some sort of activity going on in the rear of that police cruiser.
Just me holding him back like this, and as he's trying to jerk and force his way up and down, just residual movement.
Ms. Chavez has taken this video,
Yes.
right? She's talking to you as this is going on.
Yes.
Several times she says, Bish, stop hitting him or something to that effect.
Yes.
And you deny that you were hitting him?
Yes. I never hit him in the back of the car there. No.
When plaintiff alleges that you struck him or you punched him in the rear of that police cruiser, you deny that.
Yes.
It's your testimony that you were just holding him down.
Yes.
Other than holding him down, did you do anything else physical with Mr. Sargent in the rear seat of the police cruiser?
No, nothing.
You didn't strike him?
No.
You didn't punch him?
No.
And this is the time period where, as we can see, you were wearing those reinforced gloves.
Padded gloves. I wouldn't call them reinforced.
Padded gloves, okay. If we keep watching the video from 53 seconds on, let's go about 53 seconds to a minute.
Don't eat him like that.
Listen, when
So from 53 seconds to a minute, you approach the camera, right?
Yes.
And watching this video, we can see you walk up with your black gloves.
Yes.
And we can see that those black gloves have blood all over the knuckles
Yes.
of your right hand.
Yes. Over the more of the ring, looks like the ring knuckle.
You're right-handed?
Yes.
Would it be fair to say that that's your punching arm if you were to punch somebody?
If I punch, it goes with whichever one would be more efficient.
All right. So we can't see exactly what's happening inside the rear seat of the police cruiser, but we can see that when you emerge and you come over to the camera, you have blood all over your knuckles.
Correct.
But you don't know whether or not that's Melvin Sargent's blood.
I'm not 100% sure. No.
All right. So that's you talking to Jolena Chavez.
Yes.
So your explanation to her was, quote, when I tell him to put his hands on his head and he goes to grab his back, I'm going to protect me, he, her, or him.
Yes.
What did you mean by he, her?
I pointed around to there was a crowd, Pointed at everybody.
You didn't mention at that time any allegation of Melvin trying to kick you in the chest from the rear seat of the cruiser, right?
No.
Isn't it true that the use of force incident that we see in the first minute of this video, that's in response to the earlier encounter where you say that Melvin started to reach towards the small of his back where his gun was?
No. That use of force was done and over with.
But that's what you were talking about when you walked over to the camera.
I was explaining to her why he was under arrest.
Okay, you weren't explaining to her why you were engaging in a use of force against Melvin Sargent.
The first use of force, yes.
Okay, but she's filming you in the rear of the police cruiser,
yeah.
And she's crying, Bish, no, stop hitting him.
Honestly, at that point, I didn't hear her. My focus was on him, and she can do whatever she wanted.
So you're saying you weren't upset at all about the fact that he had a gun on him earlier?
No.
So at what point, I mean, we saw on the video you closed the door.
Yes.
And then you walk over and you talk to Jolena Chavez.
Mm-hmm.
At what point throughout this did you pepper spray Melvin Sargent?
After I go back towards the cruiser, he starts kicking the door, and that's whenever I go to the driver's side.
So the pepper spraying hadn't even occurred yet?
Correct.
After this conversation that you had with Jolena Chavez, how long after that was it that you pepper sprayed Melvin?
Off the top of my head, I'm not sure. It wasn't long, maybe 10 seconds, if that.
And then after you pepper sprayed him, you shut the door and left him in the rear seat?
Yes.
Did you call an ambulance for him?
No.
Why not?
He wasn't injured. He didn't complain of any injuries, and no need for him.
Okay, well, you knew that you had pepper sprayed him,
yes.
Right?
Yeah. After per protocol at the time, if there's no major injuries on scene, we would return to the office and we decontaminate them here. Well, downstairs.
Okay, you could have done it at the scene, though.
No.
Why not?
He was under arrest, and if I didn't have any equipment or tools to decontaminate him.
All right, well,
that would require me to pull him out of the vehicle and put him and others back in harm's way. That would make no sense.
All right, well, let's talk about the transport.
Okay.
What happened?
After, while we was driving, we was on Glenwood Park Road. He started cussing again, making verbal threats, started kicking the door. He almost popped it open with one of the kicks. And that's whenever we stopped on Glenwood Park Road, right in front of some church. I don't remember the church name.
And what'd you do?
I went out, got out of my seat, went around the front of the vehicle, went to the passenger rear. Callaway came up to the driver's side front, and I secured his legs. Told Callaway as we was getting in, if he doesn't comply, we'll put a hobble restraint on.
And what'd you do?
Callaway talked to him while we was holding him down, and he started to comply.
There's no video footage of this now at this point?
No.
Was the idea to transport Melvin somewhere where there was no video footage of what was happening?
No.
Isn't it true that during the transport, Melvin was complaining, roll down the window, I can't breathe?
He kept complaining to roll the window down, but I never heard I can't breathe.
He's asking to roll the window down because he had pepper spray in his eyes.
Yes, and I was driving with it as well.
Did you not have some sort of barrier in between you and he?
You do, but anytime you pepper spray with anybody, you get it as well. It splashes back, and plus it particles in the air. It's not pleasant for anybody around.
Did you roll your window down?
Yes.
But you didn't roll his down?
His was down enough to where he could receive the brief relief from the air hitting his face. It wasn't rolled down enough to where he could stick his whole body out.
At some point during the transport, was plaintiff told, stop acting like a little bitch?
I never heard that.
You didn't say that?
No.
You didn't hear Callaway say that?
No.
And you didn't see Deputy Callaway strike Melvin Sargent at all?
No.
Throughout this whole time period, Melvin was still handcuffed?
Yes.
Behind his back?
Yes.
At no point throughout this time period did Melvin attempt to flee?
No.
After you arrived at your destination, when you're transporting him, at some point did you spray down Melvin with a hose?
I did. After we arrived here at the office, we went straight into the garage. I had him kneel down, and I ran a garden hose over the back of his head, allowing the water to drain from the top of his head towards the front of his eyes.
So you basically washed off his entire head?
No, the top half where the pepper spray would have made contact with his face and eyes.
Not only did you get the pepper spray off with the hose, but you also washed blood off his face.
I didn't notice any blood.
You didn't notice any blood?
No.
Melvin Sargent wasn't provided any medical treatment at all.
Other than being decontaminated from the pepper spray, no.
He didn't complain.
No,
He didn't ask for any medical treatment.
no. If he would have, I would have called.
In fact, he did ask for medical treatment, and you told him he can wait till he gets to Southern Regional Jail.
No.
Okay, and so if he had any injuries, any lacerations, any fractures, you would deny that.
I didn't see any, no.
Did you evaluate Melvin for any injuries?
I looked him over, but I didn't see anything. But it was more of a just glance over. And I asked him if he was okay. He said, "I'm good, motherfucker. I'm good. Fuck off." His exact words.
When you pepper sprayed Melvin, do you believe that that was necessary?
Yes,
You think you could have used any lesser amount of force?
that was the lesser amount I had. I had no other tools.
Okay, well, he was already handcuffed in the back of the police cruiser, right?
Yes.
All right, so what were you trying to achieve?
Compliance for him to stop trying to kick the door and break the door open to do who knows what.
Okay, so that's why you pepper sprayed him,
Yes.
because he was kicking the door.
Attempting to kick the door open to do whatever to cause more harm or to run away. I don't know. I don't know what his goals was.
Would you agree with me that striking an arrestee in any way, for instance, punching, would be a use of force?
Yes.
Okay, and isn't it true that under your department at the time, your department policies, that any use of force that you engage in against an arrestee must be documented?
Yes.
Must be documented by you.
Yes.
You would agree with me that your report in this case, your documentation, does not mention you striking Melvin Sargent in the rear of the police cruiser.
I didn't strike him in the rear cruiser.
You did testify earlier that you did engage in a use of force while Melvin Sargent was in the rear of the police cruiser.
Yes.
Okay, but you didn't document that either.
Documented that I forced him into the rear of the cruiser.
Okay, you didn't document any sort of physical violence.
There was no physical violence. It was an escalation of I forced him to sit.
And you have no idea what may have caused any injuries to Melvin Sargent.
No,
But it wasn't you.
I don't know.
Are you positive that the blood on your knuckles wasn't Melvin's?
Don't know.
You don't know. Acknowledging that you're saying that you didn't strike Mr. Sargent while he was in the rear of the police cruiser handcuffed. Would you agree with me that it wasn't necessary for you to strike him?
There was no use for a strike in the back of the cruiser, so I didn't do it.
So you didn't strike Melvin Sargent in the rear of the police cruiser because it wasn't necessary to do so?
Correct. He was pinned against the seat and couldn't move, and there was no reason.
So you would agree with me that had a police officer in those circumstances struck him or punched him in the face, that would have been excessive?
Very much, yes.
You've had prior occasions of punching arrestees in the face before, right?
Yes.
So following this incident, you never did actually talk to the 911 caller, right? And Melvin Sargent wasn't charged with anything that occurred prior to your arrival.
No.
And you never interviewed Jolena Chavez.
No, I did not.
You never even asked Melvin Sargent about what happened prior to your arrival, did you?
No.
So when Melvin says or alleges that during his arrest processing that he was asking for medical treatment, you deny that?
Yes. I never heard him ask for anything other than the occasional threat.
About how long before you left for the transport did you pepper spray Melvin?
Right after he was sprayed, I believe it was pretty immediate.
Okay, so before the transport, you opened one of the doors, sprayed him in the eyes, and then shut the door.
Yes.
And you did that to gain compliance, you said,
Yes.
because he was kicking the inside of the cruiser.
Kicking the door and attempting to break it open.
I mean, he posed no safety threat to you, did he?
From kicking the door, yes.
And
Just because somebody's handcuffed doesn't mean they're not dangerous. They can still pose a threat.
okay, he couldn't get out that door, right?
If he would have kicked it open, he could have.
So that's why you pepper sprayed him, the danger of him potentially kicking out of the door.
Kicking the door and causing who knows what.
Did you pepper spray him to cause him pain?
To gain compliance. That's what it's meant for.
So you pepper sprayed him to cause him pain, not necessarily in your own self-defense.
For defense from the public from the area. where I was at, he would have had more of an opportunity to go through the other door. I was in a safer location.
And at that time, how many police officers were present?
There was 3 certified.
3 police officers were present and 1 uncertified police officer.
Yes.
She was still armed, right?
Yes. She was still pretty fresh.
And Melvin Sargent, on the other hand, was handcuffed, right?
He was, yes.
You had already shot him in the back of the police cruiser.
Yes.
So that was part 2 and the final bit of deposition for this particular officer. Basically, what happens after this point, after I stop questioning him, is his lawyer then gets to ask him questions and sort of try to clean up testimony. A lot of times, that's basically pretty leading questions where the lawyer is sort of picking every problem area and sort of asking a leading question. In part 3, we'll get into some of the other officers, and they're asked some of the same questions, and you'll see whether or not they answer the same. Now, remember, these are depositions. This is not trial. So there's a difference in questioning for deposition, which is more of a fact-finding sort of thing, and you don't necessarily follow the rules of evidence. And there's a big difference for cross-examination at trial.
All right, y'all. So more of this crazy story. So obviously you heard in that video that the wife was saying she was going to call someone, and they were telling her they don't care who she calls because they don't care who you call because they're the ones with the guns and the immunity or the protection. So they feel super safe. So they don't care if you call somebody else because if you call them, so what? They got all the guns and they got bulletproof vests. They feel that's why they feel like they're authority over everybody. So when you tell them, oh, you're gonna call such and such, they don't care who you call. So, and then he said he punched him. Well, he didn't say that, but he punched him in the face and stomped his hand out and broke his hand and said that wasn't violence. That was crazy. What is your definition of violence? What do you consider violent? Everything he did to this man was violent. The man was in the back of the police in a patrol car. They pepper sprayed him, broke his hand, and punched him in the face. And the cop wouldn't even roll down the window to let him breathe. He said, "Oh, you rolled down just enough so he can't stick his body out the window or whatever." Anybody who's seen police cars, you see that it's like a cage on the window. It's even if you roll down the window, the person still can't get out they still can't get out of that car. But and during this entire time, they were talking. The wife was right there, and that's who is supposed to be. That's who the report was made for. It was somebody called the police and said, "Oh, I think something happening with this couple," and when they say that, that means, or a lot of times that's a guy is beating on a woman, or a woman, and it's crazy how that's the report they're on. The report is that something is going on between this couple, and she's right there. All they would have to do is ask her what is going on right now. But they didn't do that. They just pretty much attacked this man and violated his rights. Just completely violate this man, which is insane. So the last video we're gonna watch for this section is the civil rights lawyer is going to talk about the settlement for this case. This whole thing is complete madness. I can't believe even the amount. I don't even think it was a fair amount that they settled for, because they should have got a lot more, in my opinion. Because so many different things happen based on absolutely no crime, no investigation, no nothing. Just how this cop felt about the situation. He felt like this guy, whatever, and because he didn't like the guy's reaction to not having his rights violated, he pretty much just beat him up, pepper sprayed him, broke his hand, and took him to jail because he felt like it. That's insane. So I'm gonna go ahead and play this video for the civil rights lawyers talking about the settlement for this case.
Inside the rear seat of the police cruiser, but we can't see exactly what's happening inside the rear seat of the police cruiser, but we can see that when you emerge and you come over to the camera, you have blood all over your knuckles.
Correct.
And in your job now, you don't find the occasion to punch people.
I probably will, but I haven't yet.
That was crazy that he said that.
I've done several videos on this case where my client was handcuffed in the rear of a police cruiser where his wife was filming outside.
You got body cam, I'm gonna sit right there. There you go. If you lose these motherfucking cuffs out, I'm gonna strip my finger.
Why?
And you can't quite see exactly what happened inside the police car, but then you see the police officer emerge with his bloody armored gloves and approach the camera.
All right, so listen.
So this is the final update for that case. It's over, it's settled, and my client got paid. So this is the case where I previously posted the video depositions. Here are a few bits of those video depositions that were important in reaching a settlement here. Then I'll tell you the settlement amount, which may surprise you. Now, when you punched Melvin, were you wearing gloves?
I was.
Tell me about your gloves.
They're a cloth mixed with a type of UFC type knuckle covering to protect my knuckles and anything I come in contact with.
All right, I'm going to show you what's been previously marked as exhibit number 5 for this deposition.
Yes.
Now, I'll represent to you that that is a screenshot that I took out of the video that we have in this case. Does that screenshot accurately represent your hand and your glove on the date of this incident?
It does.
I'll also show you what's been marked as exhibit number 6. I know this isn't the greatest quality, but that is a close-up of your glove, also from the same video.
It is.
Would you agree with that?
Yes.
Listen.
Don't hit him like that.
All right, so listen. When I tell him to put his hands on his hand,
I understand.
and he goes to grab his back, I'm gonna protect me, him,
I'm
her,
sorry.
or him.
I know.
They're gonna get your info. I'm taking him to the office.
Well, I know you both, so you know my info. You both know my info.
I know. She's gonna get your info.
It's your testimony that these gloves, they have reinforced knuckles.
I wouldn't say they're reinforced. You know the UFC type gloves that have like a little padding? That's all it is. It's a thing. It's just, I broke my hand a few times, so I wear it so I don't do it again. And
you broke your hand a few times punching people?
Yes, it was in a fight.
While you were working as a police officer?
Yes.
And in your job now, you don't find the occasion to punch people?
I probably will, but I haven't yet.
You said you threw those gloves away because they had blood on them, right?
Correct.
And that blood was Melvin Sargent's blood?
Not sure.
Well, they didn't have blood. The knuckles of your gloves did not have blood on them already on your first arrival at Melvin Sargent's house.
Correct. My mouth was bleeding as well.
All right. Well, you punched Melvin Sargent, you said, in the face.
Yes, in the cheek.
All right. And he was bleeding.
I'm not 100% sure if he was or wasn't. I didn't notice any cuts or.
All right. So you have no idea if that's Melvin Sargent's blood.
Correct.
So you're saying it could be your own blood. on your knuckles.
Yes.
You didn't punch yourself, right?
No, I did not.
You punched Melvin Sargent.
Correct.
He was treated subsequently for lacerations inside his mouth. You have no idea how that could have occurred.
Inside of his mouth? No, I have no idea.
That's not from you punching him in the face.
It could, I don't know.
You have no explanation for that?
No.
That is the criminal complaint that charged Melvin Sargent in this case.
Yes.
And that criminal complaint includes a narrative written by you, correct?
Yes, the same narrative.
Would you agree with me that the report that you submitted to the magistrate as part of this criminal complaint was under oath?
Yes.
Okay, so you're telling me here today that there are these inaccuracies in your report, but you never informed the magistrate that there were inaccuracies in your report, did you?
I didn't notice them.
So you didn't notice the inaccuracies in your report until today, August of 2022.
Yes.
And I'll show you what's been marked as exhibit number 3, and that is a court order or a motion form indicating that the 2 charges of battery on an officer were dismissed by the court.
Correct.
Melvin Sargent was not convicted of those allegations or of those charges, was it?
Of the batteries, no.
That shows you in the video, right?
Yes.
And you're placing Melvin Sargent in the rear of that police cruiser.
Correct.
You saw and you heard Melvin Sargent asking you to loosen his handcuffs.
Yes.
You got body cam, I'm gonna sit right there. There you go. If you loosen these motherfucking cuffs out, I'm gonna strip my finger.
Why?
Look at this motherfucker, man. I'm serious.
That section of the video, would you agree with me that it shows you engaging in a use of force against Melvin Sargent?
It does.
Look,
Stop hitting him, bitch! Stop hitting him!
stop it.
Do you also agree with me that that section of footage, 0 through 32 seconds, does not show Melvin Sargent kicking you in the chest?
Correct.
It does not show Melvin striking you in any way?
Correct.
What would you characterize as the nature of the force that you used? What did you do?
The push in, and while he was inside the vehicle, I held his head down with my right hand because he kept trying to come up, trying to spit on me.
Okay. And again, your report mentions nothing about Melvin trying to spit on you.
Correct.
Are you saying that you didn't strike him at all?
I never hit him in the back of the cruiser, no.
What we see in the first 30 seconds of this video, you're saying that no punches were thrown by you.
No, no.
Look,
Stop hitting him, bitch! Stop hitting him!
stop it.
You're just holding him down.
Yes. Hold him down, trying to talk to him, tell him calm down, quit. As soon as we get to the office,
Get
we'll
the
figure
fuck
everything out.
Man,
Stop hitting him, bitch! Stop hitting him!
Stop it.
The use of force that you did engage in at this point, in the first 30 seconds of the video, you didn't mention anything about that in your report.
No.
Melvin Sargent was handcuffed at this time.
Yes.
When plaintiff alleges that you struck him or you punched him in the rear of that police cruiser, you deny that.
Yes.
It's your testimony that you were just holding him down.
Yes.
Other than holding him down, did you do anything else physical with Mr. Sargent in the rear seat of the police cruiser?
No, nothing.
You didn't strike him?
No.
You didn't punch him?
No.
Look,
Stop hitting him, bitch! Stop hitting him!
stop it.
And this is the time period where, as we can see, you were wearing those reinforced gloves.
Padded gloves. I wouldn't call them reinforced.
So from 53 seconds to a minute, you approach the camera, right?
Yes.
And watching this video, we can see you walk up with your black gloves.
Yes.
And we can see that those black gloves have blood all over the knuckles
Yes.
Guys, listen.
of your right hand.
Yes. Over the more of the ring, looks like the ring knuckle.
You're right-handed?
Yes.
Would it be fair to say that that's your punching arm if you were to punch somebody?
If I punch, it goes with whichever one would be more efficient.
All right, so we can't see exactly what's happening inside the rear seat of the police cruiser, but we can see that when you emerge and you come over to the camera, you have blood all over your knuckles.
Correct.
But you don't know whether or not that's Melvin Sargent's blood.
I'm not 100% sure. No.
And you have no idea what may have caused any injuries to Melvin Sargent.
No.
But it wasn't you.
I don't know.
Would you agree with me that it wasn't necessary for you to strike him?
there was no use for a strike in the back of the cruiser, so I didn't do it.
So you didn't strike Melvin Sargent in the rear of the police cruiser because it wasn't necessary to do so.
Correct.
So you would agree with me that had a police officer in those circumstances struck him or punched him in the face, that would have been excessive.
Very much, yes.
So this case ended up settling for $25,000, and that may be less than you were expecting. The reality of civil rights lawsuits, as I discussed in a prior video with Kentucky lawyer Chris Wiest, is that generally you don't have a whole lot of actual damages, such as medical bills or lost wages in these cases. Many times the majority of your damages in a constitutional injury case is just attorney's fees. In other words, that's just how much time I spent on the case. Now, nobody has paid me for that time, but I keep track of it so that we can request it from the judge at the end of the case if we win. In turn, that causes the defendants to value settlement negotiations accordingly prior to trial. So you always run the risk that a jury could only award $1 or $1,000. You just don't know. And if that happens, the lawyer will still get paid if you win, but the client may not. And that's why it's the client's decision on whether to settle prior to trial. And in this case, that's exactly what happened. Could we have gotten more from a jury? Maybe, maybe not. In this particular case, the video deposition clips that I showed you were the strongest aspect of the case, in my opinion. Although there were more issues at play, including unnecessary pepper spraying, the officer's denial about what took place in the rear of the police car, coupled with the video of his bloody armored gloves as he exited the car, made it extremely likely that a jury would conclude that punches were thrown despite his denials. According to the officer's own testimony, had punches been thrown while my client was handcuffed in the back of the car, he agreed that would have been excessive. Thus, I think we would have won on that issue, assuming the jury disbelieved the officer's claim that he threw new punches, which, if they're being honest with themselves, they would. But as I said, who knows what the jury would have awarded for that? 25 grand is still 25 grand at the end of the day, especially for people who could really use that money. Also, this is the reason that there was no part 3 to the video depositions, because the case settled, for those of you who have asked. And here's another interesting thing about this case. I was contacted by a major TV network who was interested in starting a new primetime TV series based on this case, on these videos. So it focused on video depositions and civil lawsuits against the police, sort of like a First 48 type deal with interrogations, but now the tables have turned where the police are now being questioned. So I actually really think it is a fascinating idea, and I hope that somebody does run with that. Thanks for watching. Please subscribe and let me know in the comments if you would have accepted that settlement amount had this happened to you. You'll find my contact information in the description. If you have a case that you think I might be interested in, or if you think that I can help you, let me know. Also, if you want to contribute to the fight in qualified immunity, please donate to the Institute for Justice using my custom donation link, which is in the description. So we're tracking this now. So let's pump up those numbers to show how much we're donating. And let's keep those IJ civil rights lawyers running at full speed suing the government. Remember, freedom is scary. Deal with it.
All right, y'all. So that was the settlement. $25K for being violated, pepper sprayed, punched in the face, and having your hand broken. He got $25K for that. But absolutely, and the cop did that based on nothing but how he felt. It wasn't based on any laws, nothing. The guy, he hadn't broken any laws. The cop wasn't even there to investigate a crime. He was reporting on a call, and he didn't find out what the call was actually about. He sees a guy he doesn't like the way he's walking, and he goes and runs. Hey, you right there, get down and give up all your rights to me. And that is, wait, what's happening? What's going on right now? And as soon as he gets questions the cop's authority, he gets beat up, pepper sprayed, and he has his hand broken. And he got taken to jail. All that, and they only awarded him $25K. I think he would have been he would have got more if he actually took it to trial. But he settled with $25K. Which, like I said before, if $25K would like change your life or help you out in a situation, then okay, accept that. But this was absolutely insane. So for the next video, this is a update to a case of this one the civil rights lawyers. This one has first cases that was uploaded on YouTube, and so of cops basically violating our Fourth Amendment by going into somebody's house and searching their house. And so that's pretty much, they go in his house and search his house, and they broke his air conditioning. He had a window unit or something, and they pushed that down, and they pretty much broke in his house. So that would be a crime within itself, I think. You know, their version of breaking and entering only counts for people outside of law enforcement. Because if anybody else did this, they would go to jail. But I'm gonna just go ahead and play this. But what are y'all thoughts on that? You know, it's just so insane.
All right, looks like we're live. Hopefully this thing is working. Thanks for joining me. This is episode number 58, I believe it is, of Freedom is Scary. And, you know, this guy named James Otis said back in 1761 that one of the most essential branches of English liberty is the freedom of one's house, because a man's house is his castle. And whilst he is quiet, he is as well guarded as a prince in his castle. Again, James Otis, 1761. So the maxim that a man's house is his castle is older than our republic. It's deeply rooted in our jurisprudence and Anglo-American jurisprudence in general. It protects all levels of society down to, as scholars have observed, even the poorest man living in his cottage. This formed much of the basis of the Fourth Amendment itself. And while these protections, the Fourth Amendment has unfortunately eroded over time in this country, it still, you know, is important. If at least if you're walking down the side of the street, you don't have a whole lot of rights, as I've explained many times, when you're in your car or maybe even when you're in a school or an airport anymore. But in your home, at least, you have retained the original strength of the Fourth Amendment theoretically in your home. The home still receives the greatest protection under the Constitution, and it still really is our castle, the only castle we have at all under our Constitution at this point. You have the castle doctrine, you have stand your ground laws, which have expanded in the states. And now, really in 2021, we've begun what is really the decade of the Karen. And as we're going to see shortly, probably, as was demonstrated much of last year, the debate over the Second Amendment really should be over. The police aren't going to protect us. What we need is more freedom to be able to protect ourselves, not less freedom. So that's what this is all about. That's what I'm all about. Not we don't need more police. We don't need more jails. We don't need more laws. We don't need more politicians. All we need really is more freedom. What I'm going to talk about here today are updates in two different cases, and that is the drug task force search case and also the family judge search case. So I have big updates in both of those cases. If you don't know what those cases are, let me see if this works. This is the video from the original drug task force. And this is on YouTube if you haven't seen it. This is involving my client, Dustin Ellswick, who basically came home to check his cameras, hidden cameras that he had inside his house, to find these cops basically who were not in uniform searching his house, going through all his stuff. And they had basically broken in through the window after cutting a surveillance camera that was on the outside of the house. And if you haven't seen this video, it documents it, but it goes entirely through the case. And this is one of these drug task forces. This was in Putnam County, West Virginia. And the big news is that on Friday, I filed the first of these cases. And there are numerous victims of these guys. But you can see them. These are police officers who are on duty, as we allege, and searching my client's house without a warrant and really with no paper trail whatsoever, looking for drugs, presumably. But that, in case you haven't seen it, that is the drug task force search case, and we'll go over this in more detail. This other case is the family court judge search case. Can you all hear all that video? Last time I tried this, the video didn't transfer. But if you haven't seen this case, that's my client, Matt Gibson. And you're about to see a family court proceeding take place on his lawn and inside his house, allegedly.
It's a laughing game. He said it's all laughs and fun for them.
Fast forwarded some there. Is that audio working? Yeah, sound is fine. Oh, good. I've caught up with the technology.
I'm asking you right now, I'm putting in a motion to recuse yourself because you're putting yourself in a witness capacity instead of a judiciary capacity. There's no search warrant, no list of everything that we're looking for. Not today. Not today. I don't know what's in the text. So you got it? Sir, I need a search warrant. You won't get in my house without a search warrant. Oh yeah, I will.
All right. So that was the family court judge search case. There's not a whole lot of video in that because my client was forced to turn off the video and had his phone actually seized during that encounter. Real quick, Daniel, slam dunks on both cases. Of course, there's not a slam dunk in any civil rights case. Civil rights cases are usually pretty difficult cases to litigate. Some of them are slam dunks, but they don't require a whole lot of litigating. These are both difficult, both difficult cases. This one, much more difficult, involving judicial immunity. So that we'll go through that. And the judge in that case just today filed a motion to dismiss. So I'll show that to you. We'll go through it, and hopefully I can explain that. All right, but first, before we get to the updates in those cases, just to make sure we're on the same page, let's quickly just run through what the law is here. So the Fourth Amendment, we know what the Fourth Amendment is. That protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizure. That's the Fourth Amendment. So with few exceptions, warrantless searches are per se unreasonable and therefore unlawful, or if you prefer, illegal, as a matter of law under the Fourth Amendment. Okay, at the very core of the Fourth Amendment is the right of a man to retreat into his own home and be free from unreasonable government intrusion. With few exceptions, the question of whether a warrantless search is reasonable and hence constitutional must be answered no. So any search in the home, is there a warrant? If there's not a warrant, it's presumptively illegal, presumptively unconstitutional, presumptively unreasonable. All those words for our purposes mean the same thing. Searches and seizures which take place inside a person's home are illegal, which means they are illegal by default, according to the Fourth Amendment. On the other hand, outside your home is different because these protections only apply where there's a reasonable expectation of privacy, according to the Supreme Court. Outside the home, you don't need a warrant, or cops don't need a warrant unless the courts have held there's a reasonable expectation of privacy in whatever they're searching. So to the contrary, the U.S. Supreme Court has found that there is no presumption outside the home where a warrant is required because as the SCOTUS has ruled, for most places outside the home, there is no expectation of privacy. That could be bank accounts, curbside trash, open fields surrounding one's home, and it goes on and on. But the searches of a home by the government, by law enforcement, do require a warrant or a valid exception. And as of right now, there's only 2 valid exceptions, but there's a third one that's currently pending at the Supreme Court. And that is the so-called community caretaking exception. But for our purposes right now, all we have is consent or exigent circumstances. So law enforcement may enter a home without a warrant when they have an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with injury. That's known as exigent circumstances and generally means some sort of emergency situation. The need to protect or preserve life or avoid serious injury. And that, according to the courts, is justification for what would otherwise be illegal, absent some sort of exigency or emergency. And again, that is an objective rule. So that doesn't mean that an officer subjectively thought that there was an emergency, even though there really wasn't one. It's an objective standard. It doesn't matter what his actual reason was or whether he was wrong. It's whether the so-called reasonable officer would have thought that an emergency existed based on what they were actually confronted with. So let's get to the Fourth Amendment law surrounding the house. Sharky's machine, do we really have rights? With respect to your house, what I'm trying to say is yes, you do, with respect to your house, because it's on them to prove an exception. If they searched your house without a warrant, then you don't have to do anything else. That is, as a matter of law, presumptively unconstitutional. They would have to then prove that either they obtained voluntary consent or that exigent circumstances exist. Now, outside of your home, not the same thing. If you have a reasonable expectation of privacy according to the case law, then there are these protections that would require a warrant and so on, for which there also could be exceptions. And there's lots of different cases. Like I said, again, curbside trash, the GPS information with your car, bags inside a trunk, a backpack on a pedestrian. There's all sorts of hundreds or thousands of cases on these. Now, the first case that we got into, again, this was the drug task force guys. And if you haven't seen this video, this is from like January 15th of 2020 that this video was originally put up there. I'll also note that at the very
day in and day out,
this was the ending of the first video that was actually taken out because the media, this channel, threatened to sue me for copyright infringement.
That is here day in and day out fighting crime.
And that's just not the battle I wanted to fight here. So keeping my eyes on the prize. But this is what was taken out of the original video. And this was a fluff piece, basically, showing this unit of guys. This is just in this county, the Special Enforcement Unit. And I hadn't heard of them before my first client came to me with this case, with the video he had from his house. But then I got to searching, and I found this sort of fluff piece from the
They're
local
not
TV news where they're
undercover,
following
even
these
though they're
guys
not
around,
in
and they're going and
uniform.
knocking
Most
on
people are more
doors and
relaxed
explaining
with
what they
us when we're
do.
out of uniform. They'll sit down and talk to you.
They're out driving the streets of Putnam County
And this
every
is
day.
basically what they do: is they go up and they don't dress like cops. They dress like they're just, one of the guys from the trailer park, I guess. But then they also have guns. And then they sort of would, try to get information out of people by, as some would say, intimidating them, as some would say, acting like a gang. But after this original video got up on YouTube, and I'm talking about this one that I'm playing right now, I started getting calls from people just all over with their own stories of, yeah, these guys came in my house, or I had an encounter with these guys. And I heard lots of different stories where they were doing the same sort of thing. There was some video in at least one other case. Now, nothing like this. And this is just, as I've said before, one of the creepiest things I've seen. And that is police officers literally in your house going through your stuff when they think that no one's watching, after having cut a surveillance camera wire on the outside to disguise what they were doing, crawled in through a window, and they're looking for drugs, looking everywhere, and didn't document it, weren't going to say anything about it because they didn't find any drugs. But he just happened to have these cameras on inside his house. So I just thought it was really one of the creepiest things I've just ever seen. And you can see, look, there's this gun, as some would call that Mexican carry style, just sitting in the front of his pants. They went through everything. They pulled his guns out of the closets and they photographed his guns. Right here on the counter of that dresser, you can see the ashes of my client's dead friend. And at one point they grab, you can see it maybe right there. He grabs the ashes, and right there he's looking at him with the flashlight. He starts shaking them around. Maybe he sniffs them, ultimately runs them through a drug field test kit to see if they're drugs, and leaves the empty field test kits on the floor. And we have pictures of them as they were left, and it's got little bits of his friend's bones in it. I mean, just crazy. All this without a warrant. And when I later did a Freedom of Information Act request to see if there was some sort of explanation, no, there was no documentation, no paperwork trail. The only reason that these guys were there on paper was to serve a civil summons from a magistrate court case. And that's it. So I started getting calls just from all sorts of people. So the really the worst story that I heard was from this family that lived there in Putnam County. And they were afraid to really come forward about what had happened until they saw this video making its rounds on social media. And they reached out to me, and I drove to their house, even with my family. And I think my wife and kids were with me, and we sat down in their living room and I met with them, and they told me the story. And I'll tell you what, they didn't have a video because most people don't have hidden cameras inside their house, unfortunately. But they told just a compelling story. And combined with the fact that this video does exist, as well as other people who were willing to testify as to similar stories, I think it will be very credible. So here is well, if you look at the website at thecivilrightslawyer.com, I put a copy of the full lawsuit on there. Let me see if I can bring that up. All right, so there's the website. It's the last, or it's the last post on it. Well, I haven't put it up yet, but the next case I'm going to talk about, I have those things up. So I'll have it up there shortly. Let me just bring it up directly. All right, here it is. So this is the case that was filed on Friday, and this is filed in federal court in the Huntington Division because it happened in Putnam County. And if you have a federal civil rights lawsuit that occurred in Putnam County, West Virginia, that's in the Huntington Division, so that's where it goes. So this is a Section 1983 lawsuit alleging the deprivation of federally protected rights by government officials, by police officers who are acting under color of law. Notice that they're all sued individually. And also as a defendant is the employer Putnam County Commission, the political subdivision, and that's not for a direct civil rights violation claim. That's for what's called a Monell claim. And I'll get to that. Also included is a John Doe for an currently unknown supervisor to be able to make a claim for supervisor liability, which is, I think, applicable given the facts in this situation. So it's a search and seizure type 1983 claim. So here are the facts. January 15th, 2020, I had originally uploaded the video that I was showing you, showing several police officers, most of whom were not wearing uniforms, entering my client's house, Dustin Ellswick, and cutting the wires, illegally entering the residence, illegally searching the residence, and getting caught on these hidden cameras. They had entered through an air conditioning, they had entered through a window, and after pushing out the air conditioning unit, illegally searched the home, presumably looking for drugs. They didn't find any. They did take his firearms out of the storage case and took pictures of them, et cetera, et cetera. I already told you. All right, they left the house ransacked and left everything, out where they had left it. So these guys were all part of the Putnam County Sheriff's Office Special Enforcement Unit, or the SEU. And that's who these guys were. And I named them. I'll go back to it. This is who you see in the video. Brian Hall was the main guy. Xerxes Ramadi was the bigger, fatter guy. Scott Lothar, really, you only saw him at the end of the video. He was outside in tactical gear. You see him cross the bridge. He wasn't observed on the video inside the house, but he was sort of guarding from the outside. Brian Lockhart and Kenny Davis, I don't think, wasn't in that video, but he was involved in this case that I'm going to tell you about. Brian Lockhart was in the video, and these are all sheriff's deputies who are all technically employees of the Putnam County Commission, which is the actual political subdivision in West Virginia, who is the employer. Now back to the facts. Those are the defendants. These guys were all part of this SEU, the Special Enforcement Unit. And again, I showed you that fluff piece from the local news. This was just sort of a, fight crime sort of deal where they sort of look like they're cool to talk to, or they're intimidating looking when they're trying to get information out of you. That was just sort of their shtick. And let's see. And what I learned is, after talking to, dozens of people who had interacted with him around the time of this video, here's what they would do. They would obtain tips about individuals who may be in possession of, mostly what I heard was marijuana, who may be selling marijuana. So they'd find somebody who would have some pot, and they'd, intimidate them, threaten to charge them, and say, look, we'll let you out of this. You tell us who you got it from. And then they'd go to the next person's place. So they'd make a warrantless entry into a residence of a suspect in possession of marijuana. When they found it, they would get a tip from that person. Then they'd go and threaten and pressure the suspect to give them another tip, or to identify another individual who's in possession of marijuana also, in exchange for not being arrested or charged. Then the SEU members would leave, taking with them any marijuana they seized, along with any cash or firearms that they had located in the illegal search and seizure. So that is sort of the important part here, is not that they were doing this, which I'm sure other drug task force do, but that they're doing it with no warrants, and then they're taking the cash, the drugs, and any firearms they find, and they're leaving no paper trail. So no police reports, no warrant applications, no charging documents, no inventories following their search and seizure. What happened to the seized marijuana? What happened to the cash money? What happened to the firearms that were seized? They would disappear into the possession of the SCU members without ever being properly documented. How do I know that? Well, we've alleged it in the lawsuit because we've served the employer with FOIA requests, Freedom of Information Act requests, and received little to nothing in response. Only, I think maybe in one case or two cases was there any paperwork at all. In only one case was there actual documentation of, all right, we actually had a raid and entered the house and looked for or found something. Only one that I looked at. So here's the allegations pertaining to what they did to this actual family. So this happened on April 18th, 2019. The Johnson family were at their home. This is located on Poca River Road in Poca, Putnam County, West Virginia. So April 2019, sort of a suburban, nice little road along the Poca River in Putnam County. And there was actually some road work taking place right across the street from my client's house. And so there were plenty of witnesses present who were on this road work crew. And there was a bunch of people at my client's house. And they had family that were visiting from Virginia. And this is a multi-racial Hispanic family. So the father is your regular white guy from West Virginia, and he married a woman who I believe was from Peru. Everybody in the story was in this country, either a citizen or in this country completely legally, completely documented. No illegal aliens were involved in this at all. So it shouldn't even have to be mentioned, but you'll see why I have to mention it. So it's a really nice little house, a split level style house. Their home, extended family present. Everybody's having a relaxed afternoon. And I believe that the father, Bliss Johnson, was helping put together a cabinet with his father-in-law. And next thing you know, these guys arrive. And suddenly, these guys, defendants Hall, Ramadi, Lothar, Davis, and Lockhart, were all present, none of them wearing uniforms. So these police officers, they were on enforcement unit, exited their vehicles, and these are police cruisers, unmarked police cruisers. These were not personal vehicles. They approached the Johnson home, and they straight up entered the Johnson residence. They the home. They didn't seek, nor did they obtain voluntary consent to enter the home, nor did they have exigent circumstances to enter the home. And remember, we went through the law. Police officers entering a home without a warrant, presumptively unconstitutional. The exceptions which they have to prove are either voluntary consent or exigent circumstances, some sort of emergency. As we've alleged, no warrant, no circumstances, no consent. Apparently, there had been a tip that there would be some marijuana in the house possessed by the son. Instead of investigating that, doing actual police work, assuming that that was a priority for them, instead of seeking a search warrant, the defendant officers instead just barged into the house, as other people have alleged they did, just to find the marijuana. So here's how they did it. They began knocking on the front door and shouting. Within a few moments, they just let themselves in and searched the home, finding what appeared to be a dead marijuana or possibly hemp plant in the basement belonging to the son, Bliss B. Johnson. They were asked by the father, "Where's your warrant?" The officers responded they didn't need a warrant because they already had probable cause since they found what they believed to be a marijuana plant in the basement. Now, you don't have to be a lawyer to know, because I already explained it to you, is that the standard for seizing marijuana inside somebody's house, or alleged marijuana, or a dead marijuana plant, which even could be a hemp plant. Is that the standard probable cause? Oh, too late, we found it, so we don't need a warrant. Obviously not. Probable cause is the standard for a pedestrian walking down the street, and they have to have it before they search, not after. So they got two things wrong there. Still needed a warrant, but you'll see how they sort of did things. And this was particularly really made me very angry. During the search of the home, the officers forced this entire family. Again, we're talking about kids. We're talking about at least one family member who was developmentally disabled, who, although was of adult age, was like I said, disabled mentally, and forced them all, and the extended family, who the grandparents basically, who were in from, I believe, Northern Virginia, originally from Peru, but lived in Northern Virginia. It forced them to all sit around the kitchen table where they were guarded in their own home, restricted from moving away from this kitchen table. Then they were threatened. They told them that they believed they were selling heroin. Somebody had given them information that they were selling heroin. So the father sort of motioned around the room and said, does it look like we're selling heroin? It's just your regular sort of suburban house. Everything from grandparents to grandkids, just sort of enjoying the afternoon. And again, this was a mostly Hispanic family, except for the father. And what did they do? They threatened to have them deported. So they just incorrectly assumed that there were illegal aliens in the house. They threatened to put the occupants of the house in handcuffs and demanded repeatedly, we need to see some green cards. The defendant officers were also threatening to call CPS to seize the 4-year-old child who was in the home, as well as the adult child with Down syndrome, because the rest of the family, as they threatened, was going to be taken into custody. And they also rummaged through the luggage of the extended family from Virginia and went through their medications and asked them detailed and private questions about the prescriptions that they had in their luggage, which were completely legal and violating really their private health care information. But it still gets worse. Hopefully I'm not losing you here. Ann, where do you deport an American citizen? That's exactly right. Ed, well, that escalated quickly, didn't it? This was sort of their MO. You know, they'd bust in, they'd find the drugs, hopefully, and then they would just sort of use that as leverage and kind of circle the people and be like, look, you're in big trouble, you know that, and we can even charge you with a felony, so you're going to have to help us. You're going to have to tell us, you know, where we need to go next. And that was sort of the idea of this unconventional unit to really fight drugs. But this is where it ended up. So here's where they went. While the family's being guarded in the kitchen, one of the officers locates a safe under the father's bed. He was physically forced by the officers to use the combination and open the safe. Inside the safe was cash savings that they had been saving for a long time of around $10,000. Also in the safe were several, I shouldn't even have to say this because it doesn't matter because they didn't have a warrant, several lawfully owned and possessed firearms. And I'm not even talking about ARs or anything. This is like a shotgun, bolt action style hunting rifles, that sort of thing. The type of thing that you have in the gun safe or the gun cabinet or even a closet of really any home in West Virginia. So what do? The officers confiscate the cash and the firearms. They force the family to sign some sort of document, and I say some sort of document because they weren't given a copy of whatever they were forced to sign, declaring that they were donating these seized items to the Putnam County Sheriff. And I believe that was the firearms, you know, the cash wasn't mentioned. That I know of. Again, they didn't give this family a copy of this. And for the reason that I'll tell you in a few minutes. Even the agency itself didn't have a copy of whatever was signed because it apparently doesn't exist. They were threatened with physical harm if they didn't sign this document, whatever it was. They threatened to take one of the family members to the basement to choke them to death. They were threatened with criminal prosecution, with being deported, with also having their children seized by the CPS, which is a much more realistic threat this day and age. The father and the son were forced to sign consent to search forms, despite the fact that the house had already been searched. They were told that if they didn't sign the paperwork, they were going to jail. The bigger guy, Ramadi, threatened that he would take Mr. Johnson downstairs. I believe that was the son, downstairs, and choke him to death, I believe he said. Neither the donation forms nor the consent forms were subsequently located by Putnam County's lawyer after we served them with a FOIA request, with a Freedom of Information Act request. So if this is true, which I believe it is, that there was a search, there would have been on file a warrant that was produced with our FOIA request, or that would have been of record in the courthouse. If items were actually seized legally, there would be documentation of what was seized. There would be inventory forms. There would be at least whatever document they had them sign to make them think that there was paperwork and they were giving them these items. But that never was produced by Putnam County's lawyer when we served them the FOIA request. And these FOIA requests, again, are all being served after this video had already gone viral on YouTube. So everybody knew about it, and law enforcement there. And as far as their lawyers, I mean, I made sure that they had lawyers. I was dealing with their lawyers to get me the documents. If I'm misunderstanding something, that's fine. Get me the documentation. If the clients misunderstood what was happening, if there's a reasonable explanation or any explanation for this, then show me the documents. Nothing exists. They also searched the son's car in the driveway. That's Bliss B. Johnson. That was the son. They found $300 in cash, and they kept that as well. One of the officers, it was recalled, put a rubber band around it and just stuck it in his pocket. Never to be seen again by this family or by any paperwork with the employer. So what did they tell them was the reason why they were taking the guns anyways? Well, they told Mr. Johnson they were taking his guns so he couldn't seek revenge on them. Now, mind you, Mr. Johnson is not a prohibited person from possessing firearms. Instead, this father, is a military veteran and law-abiding citizen. Period. After the search, these guys instructed the son. It's confusing because they have similar names. The son to meet them at an abandoned building in Taze Valley. That's in West Virginia, where they pressured him to sign donation forms. I'm not sure if those are additional forms or that's when he signed the forms and the father signed them back at the house. They also attempted to get him to give them information of some other target who may have illegal drugs that they could kind of go do the same thing to. However, he had no information to provide. After that, they were deeply afraid of these police officers. They were too afraid to tell anybody what had happened. It wasn't until they saw this video, the Dustin Ellswick video, that they really had the courage to come forward and contact me about what had happened to them. And they didn't even know all the details. They knew what they saw in the video. But when I talked to them, there were other details that they didn't know that weren't released that really matched exactly what I already knew and had heard from other people, because these weren't the only people that contacted me with the story. So just regarding the, how we know that there was no paperwork. So you look at this little footnote. So March 2nd, 2020, I served the Freedom of Information Act request on the Putnam County Commission. This is the employer, through their counsel, requesting any and all documentation of any kind relating to an April 18th, 2019 search of their home Response provided that they had no records pertaining to the event. The only thing that they had on file was a May 2019, which is after this search. It was just a name and address for Bliss B. Johnson. I think that was the son. So after the search, no documentation from the time of the search or before the search. So there was no documentation of the fact that they were at the Johnson residence. And that's what I expected. That's exactly what I expected. If there's that documentation, fine, show it to me. But I was positive, I was pretty positive that there would be none, that there'd be no documentation, just like there wasn't for the Ellswick search. The police officers failed to document the fact that they were at that house, that they were in that house, that they seized cash from that house. They failed to document that they seized firearms from that house. To date, it's been over a year since that FOIA request. There still has been no supplementation of our FOIA request of any found documents of, oh yeah, sorry, we did have a search warrant. Here it was. We just missed it. Nothing. There's been nothing. Absolutely nothing provided. So before I get to the counts themselves, did we cooperate with internal investigators? Yes, we did. I went and met personally with the two detectives that were tasked with investigating this matter, investigating this guy's, the internal investigation. Met with them, opened my file to them, gave them anything and everything they wanted. The original Ellswick videos. I brought Mr. Ellswick and the other witness that we had to meet with them. I sent them the video, another video of somebody who didn't even want it public at all, didn't want to file a lawsuit, didn't want to be involved. I sent them that video with the person's permission, gave them the details of other cases, including this one. And I don't know what happened in the internal investigation or whether there was any discipline. I mean, I'm sure there were no criminal charges or anything like that. Absolutely. Like we boom filed a lawsuit, went straight to trying to get money out of them. We tried to go the disciplinary route, process route first, and really that was because it was the right thing to do. We had well, me as a civil rights lawyer, I had nothing financially to gain because of that, because if the agency decides to throw a police officer under the bus and say indict them, criminal charges, I've had that happen before. You know what happens? The insurance company then sends me a letter stating that, look, if a crime committed, that's excluded under the insurance coverage. We're not covering that. So we had nothing to gain by that, but it was just the right thing to do. Daniel, investigation results are public record. Not necessarily, not necessarily. Investigation results are, there was an investigation and there's going to be some documentation of that, I assume. And it's probably not something they're going to hand over as a public record in a FOIA, but it will be handed over as discovery and litigation. So I don't know what happened with the internal investigation. I heard things, but I don't know what's true and what's not true. So no, generally they are not, personnel files are not public record. But a lot of times when they take action, there will be some press release or public aspect of it. I just heard nothing one way or the other in this case. David Benner, no documentation that it must have been theft. How much is kicked back to the sheriff at all? I have absolutely no knowledge of that. I don't know. As far as the items that were seized, there's just no paper trail whatsoever. Now, they did get a new sheriff after all this stuff happened. And I'd heard things through the grapevine that the new sheriff, part of, why he wanted to be sheriff was to put an end to stuff like this. I don't know if that's true or whether he ever did. There are agencies out there who are in a good position to do things about things like this. One is in Washington, D.C., but I think they're a little bit too busy going after insurrectionists and things of that nature to be bothered with, corrupt police officers. And in fact, all they had to do that even an internal investigation really couldn't do, and that even the state police couldn't do, all they had to do was send agents in there and be like, hey, were you, because they knew about the original video before it went to YouTube. They had the opportunity. All they had to do was go in and say, hey, were you ever at this house? Were you ever inside this house? Were you inside this house on such and such date? If so, why? If they said no, boom, you had them. Why were they in the house? They've never explained why they were seen in this video. Why were they in there? What's their side of the story? I don't know. They haven't had to tell it yet to me. Have they told it to internal investigators? Have they told it to criminal investigators? I don't know. What is their explanation? What explanation could there be for being inside someone's house? Either you had consent to be there, or you had a warrant, or there was some emergency happening inside. Those are really the only exceptions. Now, what do I suspect is the reason? And I've said this before. What do I suspect was their justification in their minds? Well, here's what I think was going on: is they had what they were there to serve that day. Now they knew, we would argue, they knew that my guy wasn't home, that he was at work. They knew that because there was a phone call to the employer. Again, new information. No one knows this yet. There was a phone call to the employer earlier that day, as if checking to make sure that my client was not home. So they go to the home, and there's several police cruisers there. Again, they're on duty. They're in police cruisers. No uniforms, but they're in police cruisers. They got guns. At least one dude's on the video. You'll see him with a sheriff badge on. Where is he?
January.
No. There he is. All right. So see that guy? That's Lothar, Scott Lothar. So it says sheriff on his badge. So, I mean, it is really no way to claim that you weren't there in a law enforcement capacity, but I suppose they could, maybe they have to. But here's what they're going to say is they were there to serve civil summons paperwork, because here's what happened is the client's mother somebody saw a bunch of police cars at my client's house and contacted him. And then his mother went to check on, what in the world is going on in my son's house? And she had a witness with her, and they confronted these guys at the house. So boom, they were caught red-handed. And that's how we know about it. And they didn't know they were on video at the time. And so that's when they said, oh, well, we're here to serve this. And the mother was kept away from the house, but she was shown the civil summons paperwork. And it was a eviction summons. So it was an allegation he hadn't paid all his rent yet. And he was the beginning stages of an eviction lawsuit had started. There was no court order or anything. It was just a lawsuit that you have to serve on people. And ultimately, he wasn't evicted. He had made a deal with his landlord over what the dispute was, and it never proceeded. But they were there to serve a civil summons. So here's what their allegation might be: is we had the permission of the landlord to be in the house. That might be what they were going to say. So that brings up the question. All right, well, say the landlord hired these guys or sent them there because they weren't the process servers for the county. And I can go into who the process server was. It was neither of these guys. The real process server wasn't there. So I don't know how this ended up happening, but they were there to serve the paperwork on behalf of the landlord procedurally. So what if they say the landlord gave us permission to be in the house, and even the lease says that we get to go inside the house, or the landlord gets to go inside the house to inspect it? Well, that doesn't do much good for them, because there's like a 1950s or 1959 U.S. Supreme Court case that says a landlord cannot give the cops permission to go inside the tenant's house to search. Period. I mean, very, very well-established case law. That was from a moonshine case where the landlord had every reason to believe there was a illegal whiskey still inside his structure, that they weren't even real tenants, that it was just a front. Called the cops. Cops, ironically, climbed in through the window, ended up convicting the guy of all sorts of crimes for running a moonshine still inside this landlord's structure. And everything's thrown out, goes to the Supreme Court, and they hold it. No, that was an illegal search. A landlord cannot give permission to enter a tenant's house. They still have to go get a warrant. So if that's the explanation, then it's just, they were mistaken about what the law is, if that's their explanation. So that won't do any good. So really the only way out of that is to somehow come up with a search warrant. Because there's no way to come up with consent. There's no way to, I don't see how you could come up with an emergency or exigency excuse. And I'm not gonna give them any theories to work off of, but there's really no excuse for it. So here are the claims in this new case. Okay, count one, basic, unreasonable, and therefore unconstitutional search and seizure, violation of the Fourth Amendment. And you'll see that it's very, very specific, so that it doesn't get knocked out on a motion to dismiss. But it comes down to this: no objectively reasonable police officer would believe that they possess the authority to enter this home without a warrant, without voluntary consent, and without exigent circumstances. And same thing for seizing items, including cash money, firearms, even a dead marijuana plant, without a warrant, without voluntary consent, without exigent circumstances. So again, this is about a different search than the one from the video. And this one was filed first because the statute of limitations approached first. So this happened like 5 or 6 months before the one from the video. And this happened under color of law. They weren't there in any other capacity. Now, count two, Monell claim. Remember, the county commission itself is a defendant in the case. That's not because the agency is liable for the conduct of their employees. You have to establish what's called a Monell claim, that they had basically an official policy or pattern of practice of engaging in civil rights violations. And that's really, this might be one of the rare successful Monell claims, because this is sort of what we had here: an official policy, custom, and practice of violating the rights of homeowners in that county, engaging in a pattern and practice of warrantless searches and seizures under auspices of fighting against illegal drug use and crime. They wore no law enforcement uniforms, gave the appearance they were acting sort of outside the law. No rules, no documentation, no paperwork. And this allowed the use of intimidation and sort of a perceived lawlessness to more effectively and efficiently acquire information and sources. And as you've heard me say before, if you've watched my videos, the Constitution is designed in such a way as to not be efficient, as to not allow the government to be efficient and effective. So that's not the standard of constitutionality. It's not, well, this works better. No, it's supposed to be hard to go in someone's house and search. I mean, it's part of the reason that we fought the Revolutionary War. All right, so in accordance with that official policy and a practice, what they did in this case to this family was also done as a part of that same practice that they had. And they did commit other similar violations against other victims in Putnam County, West Virginia, others who will be the plaintiffs in lawsuits, and others who may just be witnesses. We'll see. Count three, supervisory liability. This is the John Doe. Now, who was the supervisor of these officers? I don't know his name, but definitely he had actual knowledge that these guys were engaged in conduct that posed an unreasonable risk of constitutional injury to the plaintiffs, that they would be searching people's houses and seizing their stuff without a search warrant, potentially, or any other exception to the search warrant requirement to the Fourth Amendment. So I can't imagine how the supervisor was doing a good job of supervising these guys. So let me put the video back up, go back to the
We are
end.
here in Winfield to
I mean,
open
heck, everybody sort of knew if you
fugitive
watched the
files
local
and look
news.
for fugitives from around Putnam County. And this is the group that is here day in and day out fighting crime.
When it comes to fighting crime, this group can't and doesn't do it alone.
The more people that find out we're out here, the more information we're getting.
They're a group of 4 Putnam County deputies, but together they make up
Those
the
are my
Special
words
Enforcement Unit.
on the top, obviously.
They're not
Not
undercover,
the
even though they're
news
not
stations.
in uniform.
Most people are more relaxed with us when we're out of uniform. They'll sit down and talk to you.
They're out driving the streets of Putnam County every day, checking on tips called into the agency's anonymous drug tip line.
A lot of times it is people calling in on their neighbors or people in their neighborhood, or they observe a lot of traffic, unusual traffic at different times, late at night.
They also serve warrants and track down fugitives in the county. Just recently, the group became deputized to work with the United States Marshals Cuff Task Force.
The Marshal Service, not only do we go with them, but they're willing to come to our county and serve warrants as well.
Since their formation, hundreds of arrests have been made. They've captured accused heroin dealers, uncovered drug operations, nabbed fugitives, and all with your help.
If they wish to remain anonymous, they're going to remain anonymous. We don't tell people where the information come from because we want more information. We want people to call us all the time.
Proactive policing made possible by those who don't want crime in their neighborhood.
All right, so that's like verboten news footage I had to take out of the original video. I didn't have to, but I think it would have been a distraction to fight them over that. So it'd be hard to claim that nobody knew that these guys were doing this sort of thing when that was sort of the stick they were allowed to run with, of like, all right, you're going to be this like unconventional like Delta force of Putnam County where you're gonna like bust into people's trailers and find out who their drug dealer is and so on. So that's that case. Again, these cases are going to kind of run together, but it's been a long time coming, and people have asked me over and over and over again, what's going on with that drug task force case? Well, it's now come to fruition. Now we're going to litigate it. We're going to get the opportunity to take depositions and see what their official side of the story is. And again, why did it take so long? Well, we participated in and gave them every opportunity to conduct their internal investigation. Waited and waited and waited to hear, waited and waited to see if they were going to sort of make things right with the clients as well. You know, we don't have to file a lawsuit if they're going to, step up and make things right. But they didn't say they weren't going to, but they just never did and kept putting it off. So here we are. So now we're going to litigate it. So that is the first of the drug task force cases, and there will be others filed very, very shortly, including the Ellswick one. Again, their choice, not ours. Now, the other, well, let me check, see if there's any recent questions here before I move to the family court case. Yes, West Virginia Freedom Task Force, absolutely. The shirts tell you that, the 1776 and the American flag on the shirts. Yes, they're fighting for your freedom while they're in your house searching through your stuff. David, what does the supervisor know? LOL, I would be checking on individuals and units even late at night and early dark 30 in the morning. If you had to be babysat, you did not work under me. Well, I think that might play a part in it. I mean, clearly I guess at any job, it'd be great to be like, all right, if you're a cop, I'm not saying I would not ask for this. All right, I want to both be a cop, work at your agency, but I don't want to wear a uniform. I want to wear like just grunt style shirts and jeans. And I want to like Mexican carry my Glock, but I won't carry one in the chamber so I don't shoot my junk off. And I want no supervision. Now, that one guy could have had a holster technically. I didn't see whether it was a Glock or not. There are little holsters like Raven Vanguard concealment holsters that I've used myself that you can appendix carry like that. And you can't tell that they just sort of cover the trigger on a Glock because that they don't have a manual safety. So I'm sort of being tongue in cheek. There could be a holster there. I don't know. The point is that there was really no supervision. And that's the point. If there's no supervision, you're turning these guys loose on the local trailer park. And I'm being facetious because the clients I filed this on behalf of are not in a trailer park. Very nice neighborhood, nice home, nice family. The Dustin Ellswick video you can see is a rural farmhouse. I mean, I think it was a log cabin actually. It wasn't a trailer park, wasn't a drug area. I mean, these are just regular good people that are being terrorized by what is a bunch of cops looking and acting like a gang. Those are the allegations. And therefore, I would like to hear what the supervision was. And if the defense is for the supervision that, well, there was no supervision, you can't blame me, that sort of makes the claim that, well, there was a lack of supervision because, you did set up this SEU and you did turn them out onto the community and you even told the news about it, but you didn't watch them at all. You didn't look to see whether they were getting search warrants or whether they were seizing things, and if so, what was happening to the things that they were seizing. Okay, and I'll do more on that case as this progresses. So now to move on to the family court case. Again, that's this case.
There's no search warrant. They listed everything that we're looking.
That's the family court judge with her back to you. That is her bailiff. I believe his name is McPeak. Standing to the right, that's the ex-wife's lawyer that you can hardly see in the green suit, and then that's my client, Matt Gibson, to the left. So watch that video if you haven't seen it. This is the complaint that we recently filed. I'll just briefly show you the complaint. So that's the complaint. Also, Southern District of West Virginia, federal courts. Now this one, instead of Huntington Division, this is Beckley Division because it took place in Raleigh County, West Virginia. Also a 1983 case, also for an unreasonable and therefore unconstitutional search and seizure of the plaintiff's home. Now this is a more recent search. This happened on March 4th, 2020, right before this giant state of emergency was declared that we're still living under. Again, that's a different video. I don't need to go into that. Plenty of other videos that you can hear my opinion on that. So we filed this lawsuit. I've gone over it before, but basically a 26-year family court judge literally searches my client's house, brings the ex-wife and her lawyer in and law enforcement, and allows the ex-wife to look for certain items of personal property and to seize them and leave the premises with them, under the auspices of it being basically a home view version of a family court hearing, that they literally left the family court and resumed the hearing in my client's front yard and then took it inside the house. So when I first saw the video, I was like, this is crazy. I've never heard of this before. We put it on YouTube. The news picked up with it, and also the Judicial Investigation Commission picked up with it. And they ended up investigating the judge and filing a formal statement of charges against the judge and one other judge who was doing the same sort of thing at least twice. And that's still really being litigated. But ultimately, we filed this federal civil rights lawsuit, and that's it. You can read it. It's up on the website. What happened today? So there's news today in that case, and here's what happened. So we just filed this lawsuit on March 22nd, and we served all of the defendants. It just had them served with a copy of the complaint and the summons. And so now all the answers were due today, and we had several motions to dismiss that were filed. And so that's what was filed today. And if you look at the website, thecivilrightslawyer.com, you will see the motion or the memorandums that were filed arguing for dismissal of our lawsuit. It's exactly right that and they wouldn't have gotten away with it if it wasn't for us meddling kids. Bubba, no rights in your house, no rights in your car, guns being taken away, America, land of the free. Well, this is a really interesting case when it comes to home rights, because there are people arguing, including family court judges, that this is absolutely legal for them to do, that there's no Fourth Amendment right to keep a family court judge or any judge out of your house if they want to go search your house. It's really bizarre. And here is again, if you go to the website, I have these filings, civilrightslawyer.com, but we can look at a better version of them. So let me look at first. Do you want to look at the judges first or the cops first? Let's look at the judges first. That's the most interesting. Okay, so here's the judge's filing that came down today. Just received it. I've had enough time to breeze through it and jot down some notes, basically. But this is it. This is written by the lawyers, the defense lawyers. So they go through all the legalese. And let me get to the substance of it here. And so this is absolutely expected. So here's their big argument. As a judicial officer acting in that capacity as a judge, Judge Goldston is absolutely immune from plaintiff's claims. So it's well settled that judges are absolutely immune from a suit for deprivation of civil rights brought under Section 1983, even if such acts were allegedly done maliciously, corruptly, or in bad faith, and no matter how erroneous the act may have been, and however injurious in its consequences the judicial act may have proved to the plaintiff. So, as they note, it's a form of absolute immunity. It doesn't merely protect them from being assessed damages, but also from having to participate in a lawsuit at all. And that's the same thing of qualified immunity. It can be brought up at a motion to dismiss stage. It can be brought up at any time up to and even during the trial. And really after the trial, on appeal, it could be brought up. So qualified immunity or even judicial immunity or absolute immunity can be brought up anytime. And a lot of times it isn't brought up this early, but I absolutely expected judicial immunity brought up very early in this case, as I would if I were the defense lawyer. So just some of the other legalese, and I'll get to what the law actually is. So absolute immunity. So even though it may be unfair, a general principle of the highest importance to the administration of proper justice is that a judicial officer, in exercising the authority vested in him, shall be free to act upon his own convictions without apprehension of personal consequences to himself. Let's see. So they cite the Morellis versus Waco case. Now, this is an interesting case, the Morellis case, and I think I cited that in the complaint, but the Morellis case was a Supreme Court case from 1991. I was thinking it was 1985, but it's a fairly old Supreme Court case where a judge got sued by a lawyer for a Section 1983 claim for excessive force. And here's what the judge did. The judge basically said to her bailiff, or to his bailiff, it was a guy, he said, I want you to go get, lawyer John Doe, or whoever he was. Maybe it was Morellis. I want you to go get this guy. He's in a different courtroom. I want you to go get him. And when you get him, I want you to use excessive force. Bring him back to me and make sure you use excessive force. So being the trustworthy bailiff, the bailiff went out and actually did go get this lawyer and used excessive force when brought the lawyer back in. So the lawyer sues the bailiff and also sues the judge. And the judge gets out of it in that case, claiming that, judicial immunity. And the Supreme Court held that, while it was wrong what the judge did, it did violate the attorney's rights, that judicial immunity applied because literally the judge was still sitting on the bench and it was still acting in the judicial capacity, sufficiently in the judicial capacity, when this thing happened. And I'm paraphrasing, we can go through that. And there are allegations here basically that the judge says that she continued the hearing to the client's front yard and to the litigant's front yard and was having the hearing there and then took the hearing inside the house. And because a hearing was still being conducted, she should get the lawsuit dismissed based on judicial immunity. And that is I'll get to my response to that. And here's the other thing that was bizarre that they brought up. I wasn't expecting this. I'll take a look at this. They're saying that the federal courts lack subject matter jurisdiction over the plaintiff's claims due to the application of the 11th Amendment. Now, do you know what the 11th Amendment is? I know what it is. I've litigated before. Here's what the 11th Amendment says. The 11th Amendment says that a state, you can't sue the state in federal court. That's why, see, I can sue the Putnam County Commission, as we just went over. I can sue them in federal court. They're a political subdivision. They're not the state. So since they're not a state, the 11th Amendment, which says that the state can't be made a party in the federal courts, doesn't apply. So if I were to sue, for instance, the numerous times I've sued a West Virginia state police officer, a state trooper, I haven't been able to say in federal court, I'm suing the West Virginia State Police because they're the employer. Now, one of the main reason I can't do that is because of the 11th Amendment. I can't sue a state agency in federal court unless they agree for me to do so or under certain exceptions. Generally can't. I have to name the individual officer. And so I name the individual officer, Trooper so-and-so, as an individual. And when I do that, the 11th Amendment doesn't apply. It doesn't apply at all. And so I'm not sure why they think it applies here. Because if we look back at the complaint, let's do it. Well, actually, we don't even need to look back at the complaint. Let's look at their own memorandum. All right. Let's look at the top of their own memorandum. All right, there's the judge. How is she sued? Individually, as an individual. And so in the complaint, it specifically makes clear in one of the first paragraphs that this defendant, as with the other defendants, are being sued individually, because I know you can't sue in the official capacity because that's the same as suing the state itself if it's a state employee. You can't do that, the 11th Amendment. But it's as if they don't realize that. I'm not sure, but they pretend that this is an official capacity claim, since she's a family court judge, which is technically falls under the judicial branch, the state judicial branch, the state Supreme Court, that we're basically suing the state court system. And this is outrageous. And it's 11th Amendment says you can't do that. But we're not doing that. And so they go on and on about this. 11th Amendment says that you can't sue a judge, but we're not, or that you can't sue the state. We're not suing the state. We're suing the individual. And I'll just to pound that point home, let's bring the complaint back up. All right, here's the complaint. Wait, that's not the complaint. Here it is. All right, at the top, the judge. Well, I can't highlight that one. Louise E. Goldston individually. And let's look down at the parties section. See parties, paragraph. Let's see, where is it? Okay, defendant Louise E. Goldston was at all times relevant here too, a judge of the 13th Family Court Circuit, has served in that capacity for approximately 26 years. At all times relevant to the allegations herein, she was acting under color of law. She is named herein as a defendant in her individual capacity. All right, so how can they argue that this is an official capacity claim where they could bring up a defense of the 11th Amendment when it's an individual capacity claim? I don't know. Maybe just trying to confuse the judge, or maybe they don't quite understand that. It can be confusing, but the 11th Amendment cannot apply to that. 11th Amendment does not say that you can't sue somebody who is a judge in their individual capacity. Now, the doctrine of judicial immunity says that you can't do that under some circumstances. So before we get to the officer's case, let's just talk about that. What does that mean? What does judicial immunity, when does it apply? When does it not apply? Again, we looked at the Morales, I don't know how you pronounce that, Morales versus Waco case, 1991, U.S. Supreme Court. That is the case that they cited. And it expressly says that a judge is not immune from liability for non-judicial actions, i.e. actions not taken in the judge's judicial capacity. Secondly, a judge is not immune for actions that judicial in nature are taken in the complete absence of all jurisdiction. So those are the two exceptions. And so how do we know when they apply? Well, it's being case law, it goes on and on. Whether an act by a judge is a, quote, judicial one relates to the nature of the act itself, whether it's a function normally performed by a judge, and to the expectations of the parties, whether they dealt with a judge in his official capacity. I'll bring this up for you as well. These are just some of my own research that I've compiled. Just some of the notes that I compiled researching this. So look, here's the law. Judge is not immune for liability for non-judicial actions. Actions not taken in the judge's judicial capacity. Whether an act by a judge is a judicial one relates to the nature of the act itself, whether it's a, well, let me zoom in some here. I don't know if it'll let me make this any bigger. There we go. Whether an act by a judge is a judicial one relates to the nature of the act itself, whether it's a function normally performed by a judge, and to the expectations of the party, i.e. whether they dealt with the judge in his judicial capacity. And in the Morales case, they found that a judge's direction to court officers to bring a person who is in the courthouse before him is a function normally performed by a judge. So, all right, they rely on the Morales case. So the judge is on the bench and says, go get that damn lawyer, and I want you to use excessive force when you bring him here. Okay, that is an act that normally judges do all around the country. They may say to a bailiff or to any other person, go get this person, go get this lawyer and bring him in the courtroom. That is completely fine. What makes that wrong? What happened? It was that the judge said, I want you to use excessive force when you did it. Now, can we contrast that situation with what happened to my client, Mr. Gibson? Is it a function normally performed by a judge to go to a litigant's house and to search their home? To physically go on their property and go walk into their home and walk downstairs and sit on the recliner and direct guys with badges and guns on where they can go, where they can't go, what they can take, what they can't take, to bring an ex-wife in the house and her lawyer and to let them take pictures or DVDs? Is it within a function normally performed by a judge to allow or to force one in their own home to open up their safe to allow their ex-wife to look in it or law enforcement to look in it? No. These are not functions that are normally performed by judges. And that's a big difference from what the Morales case says. Judges do not search homes, period. They don't do it. So what does judicial immunity protect from? Well, it protects from judges being sued over making mistakes or acting in excess of their authority, but they're still sitting on the bench and just took it too far or something like that. This is so outside of what judges do. Nobody would expect in any court in the country, whether family court or any other type of court, that a judge is going to go search their home. Absolutely not. So the relevant inquiry is here. The relevant inquiry is the nature and function of the act, not the act itself. In other words, we look to the particular act's relation to a general function normally performed by a judge. In this case, the Morales case, the function of directing police officers to bring counsel in a pending case before the court. So a judge's direction to an executive officer to bring counsel before the court is no more executive in character than a judge's issuance of a warrant for an executive officer to search a home. So the issuance of a search warrant is a judicial act. So therefore, what is not a judicial act? So there's a difference between judicial acts and executive acts. So the judge, a judge generally can issue a search warrant. Now, a family court judge in West Virginia can't, and that's a different area that we're getting into. But just any judge, it would be a judicial act for them to issue a search warrant, not under any circumstances to go personally engage in the executive act of enforcing that order. That is an executive function. That's what law enforcement does. Let's see. And there's a few other cases in there. And another case, the stump case. Ironically, we have a stump defendant here, but the court must assess whether the party is expected to deal with a judicial officer in that officer's judicial capacity. So generally, as a party in any court, you don't expect a judge to come search your house. Now, maybe they argue that was the expectation in this particular judge's court because it had been happening there for 26 years. But my client was not a litigant there for 26 years. This is something that he had 10 minutes notice of. He's there representing himself, and the judge says just sua sponte, which means the other lawyer didn't even ask for it. What's your address? We're going to your house. Be there in 10 minutes. And so, like I said, this judge got charged with a formal statement of charges by the State Judicial Investigation Commission. And one of the allegations, which was admitted in writing, was that the judge in this case improperly left the role of unbiased and neutral judge presiding over a case and entered the role of a litigant. So entered the role of representing my client's ex-wife, because this was a contempt proceeding. And one of the things that the judicial prosecutors brought out here was the admission that there was no even, she didn't even make the other lawyer prove contempt before they went to the house. So he wasn't held in contempt. This was a part of them attempting to prove contempt, allegedly. So she had basically acted as a litigant or as a lawyer against my client, that she took the role of proving contempt by taking everybody and forcing them into his house under threat of being arrested and jailed, and brought them in the house in order to see if these items were there, and that therefore to see whether or not he was in contempt. And it just violated a number of judicial rules, almost all of which the judge admitted with counsel to violating all these rules of judicial conduct. So it's going to be, I think it's a difficult argument to say that judicial immunity applies because of the Morales case. Well, it's a little different, because when she chose to go off the bench and enter the front yard, it's a little hard to claim that. Andre, thanks. I'm the best advocate for fair, common human rights and treatment simply by embracing the U.S. Constitution. I appreciate that. Sharkies. Why do police, I guess you're talking about the other case, why do police get to investigate themselves? Well, I guess anybody can investigate themselves, any company, any agency. I mean, no one's stopping them. The fact is that, why isn't some other agency investigating them? I don't know. Karen, who is the ruler of Yard? Well, I'm glad you asked, Karen O. There is a Supreme Court case, I believe it's Florida versus Jardines, which states that the area outside of your house is really treated like the inside of your house as well. I can get that exact quote for you here.
All right, y'all. So this was basically the rundown of this case he has going on at the time this video was taken. But I want to switch it up and go into this video of how the cops treated a man with dementia. It's absolutely disgusting the way that these cops are acting with somebody with dementia. This is an old person with dementia, and watch how he's treated in this video.
You're trying the PBT, trying to communicate with them. They're realizing this is something medical. The jail guard says to Officer Godby as he's walking by, it could be his blood sugar.
Please keep yourself, come on. Come on, please. Keep yourself in your hand.
Odds are good you might end up bringing him over to the hospital. Just this is.
Yet again, more body cam is out in the case of the elderly dementia patient in Danville, Kentucky, who was arrested in Walmart as his wife was shopping. First, I showed you the footage of Mr. Hardwick's arrest.
He hasn't stolen anything, but he did walk in the back behind the customer service desk and grab these off the shelf. See, and he keeps sounds like enough for shoplifting for me.
Where Officer Godby,
he just said he didn't steal anything, and this cop says that's enough for shoplifting to me, even though he didn't steal anything. How insane, how stupid are you to what do you mean? He just said the man didn't steal anything, and the cop said that's enough for shoplifting to me. So y'all see how this is about to go.
he punched him 6 times, and then they handcuffed him.
You're under arrest.
That's why I said no.
Yeah, absolutely.
And despite his cries that he was in pain, they treated him like garbage, basically threw him in the back of the police car.
I'm not taking these off of you until you get inside the jail.
It hurts do you want me to put you in there, or do you want to get in there yourself?
What are you doing? Oh, goddamn.
Then in my update video, I showed you the body cam footage from when they were at the hospital. The cops were gaslighting everybody, pretending like this guy was drunk and not a man with severe dementia.
He was trying to shoplift alcohol from Walmart. We believe him to be intoxicated.
The only thing we were missing was what happened in between. What happened when the cops tried to take him to jail and the jail wouldn't accept him?
We got him out to the jail, and the jail refused him because of his erratic behaviors. So that's why we're here.
No wonder they did not want you to see how he was treated there. We had never seen the footage from that.
I'm not doing shit until you get over there like I told you to, so I can pat you down. Would you shut your mouth? Take your shoe off. Please shut up. You've been this way the whole time?
At the hospital, they made no mention to Mr. Hardwick's wife that they were claiming he was intoxicated rather than suffering from dementia. The officers wrote in the report, while at the hospital, Hardwick's wife arrived and spoke with the doctor. Hardwick's wife stated Hardwick is a binge drinker. That conversation never happened. In fact, the officers purposefully never mentioned any allegation to Mr. Hardwick's wife that they were saying he was intoxicated. They are completely incapable of telling the truth.
We got him out to the jail, and the jail refused him because of his erratic behaviors. So that's why we're here.
It was all about dementia to her.
When that gets to court, they'll probably dismiss it all, and you'll never hear anything else.
To court and can't even comprehend what he's going to court for. I may not end up getting there. You may have to come to the house and get him.
I understand.
When we go to see a doctor now, I have to do it.
I understand. And you will be able to, I'm sure you can make arrangements, I'm sorry, with the courts, and we will let them know also what's going on and that we spoke to you and his medical conditions and that sort of thing. So wife's down here at the hospital. She's saying that he has an LTD. I don't know what that means, but I'm sure it's, she says that it's progressively gotten a little bit worse. She lets him go to Walmart because that's one of the few places that he'll actually go now. We're fine with releasing him to her, talking to her, seeing him a little bit more. There may be something cognitively going on. It's really sad. And she said that Walmart's one of the few places that he'll still go, which he won't go there anymore after what. We try to help you all out a little bit, but our hands are also kind of tied in the situation. We hate it. We don't want to have to do those types of things, but we also didn't know. But I will let our dispatch know. It will go in our system. That way, if anybody in Boyle County runs him, it will come back that he has dementia. Yeah, and I will also get your name and phone number and attach it there. That way they can call you.
Thank you.
Okay.
Thank you.
You're very welcome. No, it's okay. I mean, this is all things no one tells you, about. So unfortunately, it takes an event like this to get stuff rolling. So I've talked to the doctor. She's going to try to get you all processed and get you out of here. Okay. All right. All right. If you need anything, please give me a call. Okay.
Meanwhile, they were gaslighting in the report, claiming that they believed him to be intoxicated. The officers wrote in their use of force report, while at the Boyle County Detention Center, jail staff stated they could detect the odor of alcoholic beverage coming from Mr. Hardwick's person. Hardwick refused the PBT and was refused by jail staff. We now know that was an outright lie. The jail staff said exactly the opposite. They said they did not smell the odor of alcohol.
No, that's what reason is I don't get a really strong smell of alcohol.
And they believed that he was suffering from a mental condition and that he was not intoxicated.
Yeah, it could just be drunk, possibly, but yeah, this could also be medical.
What's your name?
I just went some
What's your name?
went some ball things over there, and
What's your name?
I don't know why I'm doing all this down. Yeah, it could be blood sugar too. Odds are good anyway. That brain of the laws, but just this is what you.
This footage, which was just provided to me by Mr. Hardwick's lawyer, proves that those were all lies. This is the actual moment where Mr. Hardwick was taken from Walmart and brought into the jail. Here you can see the actual encounter as it happened between the jail staff and Mr. Hardwick, and also Officer Godby, who had arrested him and punched him 6 times.
Hey, come over here and get this off my finger.
How are you, sir?
Feels like it feels good out there.
It feels a lot pretty good. If the wind would stop blowing, then come on out here. We'll take you off.
Oh, this thing is hurting my fingers. Oh, damn it. Oh, can you get this off my fingers?
When we get up here.
It's hurting my arm. Look at this. Get that off there, please.
Okay, walk up there for me.
Come on. Get this off, please. These are hurting my arm.
I know they weren't designed to be comfortable.
Hey, can you get this? This thing is hurting my finger bad.
I know. Becoming a regular around here. All day, every day.
Oh, gosh damn, these things are hurting. Oh, my finger. Get that down, please.
Whenever he's ready, I'm in his house, sir.
Get down. Get over there so I can pat you down. It's getting down on my finger. Okay, I'm not doing shit until you get over there like I told you to so I can pat you down. Get that down.
Over here.
Come on.
Right there.
Oh, please get that off my finger. What did I just say? What did I just say? I said I am not taking that off until I have patted you down. Stop asking me. These are my finger. Oh, damn, these things are hurting my fingers. Come on, get these out. Would you shut your mouth? Take your shoe off. Please get this off. Step out of your shoe. Please get this off my finger. Step out of your shoe. It hurts my. Oh. Golly. Please get this off. Oh, hey. Let's see. Oh. Please get this off my fingers. Please shut up. This is the one I'm telling you. Get off my finger, please. It hurts my finger. Oh, well, lucky for you, nothing's on your finger. It hurts my finger. It hurts. You've been this way the whole time? So fucking annoying. Every time. Please get that off. It hurts my finger. Oh.
As Godby looks on, the jail intake guy tries to search Mr. Hardwick, for weapons as part of their regular intake procedure. This was the first sign that Mr. Hardwick appeared not to understand what was going on, didn't understand what he was being asked to do, didn't understand why he was in handcuffs still behind his back that hurt him. So what do? They put him in this restraint chair, which appears to be sort of a punishment for not following their directions quickly enough.
Oh, but sorry, you made a decision to have to do with this one. Oh, these are breathing my finger. Yeah. Oh, you got some move right there. Oh, gosh, they're hurting my finger. Your finger, but it's nowhere near your finger. So explain me how there's that. Oh. Please get it off, please. Can you get it off? Maybe you shouldn't have twisted your wrist like that in the cuff. Oh. Why did you twist your wrist all up? Oh, good. Oh, why did you do that? Thank you. Oh. You're not listening at all, are you? Oh, thank you. Are you drunk? You drunk? It's hard. Are you drunk? Oh, gosh, man. Are you drunk? What are you doing? I just went to things. It's really annoying. What's your face? Yeah. Your finger is nowhere near. No. Have you been drinking? Oh, yeah, it's possible. The list can be up on that. Why are you bringing me down?
You shoplifted beer. As I explained in the first video, he absolutely did not shoplift, which is why the charges were dismissed and he was never convicted of that. The Walmart employee told them that he did not steal anything.
He hasn't stolen anything, but he did walk in the back behind the customer service desk and grab these off the shelf.
Because he has dementia and he did not understand what was going on. He was trying to pay for the beer. And it becomes more apparent to everyone watching that he has dementia. He can't even tell them his name or why he's there.
I don't know what you're doing up today. Well, you don't even know your name, so why would you know why he's bringing you in here? I just got to do things, and I don't know why y'all went down. I've done it before. Wait, what are you talking about? No, leave it hurts. So what's your name? I don't know what my name is, right? I don't know what's going on. Hey man, he's not listening to anything I'm telling you. I won't tell you he's not listening.
John Hardwick.
Spending all this time just commenting on stuff, touching his fingers and hurting his fingers. It's nowhere near his fingers. Why is this? He just seems really high. What's wrong? I just put some things down there. All right. Did you have a PBT?
I didn't try.
The odds of us being able to get one are pretty tiny.
That's why I didn't attempt.
Yeah.
The jail guard asks Officer Godby if he had performed a PBT, a breath test, to see if he was, in fact, intoxicated. Godby replies that he didn't even bother to try. So he's going to get this PBT. In the meantime, he had called for this nurse or this medical person or whatever, and she's there sort of evaluating Mr. Hardwick, poking at him, asking him questions, and she's sort of incredulous that he doesn't know his name, he doesn't know why he's there, and the whole thing just continues to roll downhill from there.
Do you take any medication? Hey, look right here. Hey, do you take any medications?
I just went through things down here. Do
you take any medications?
No.
Okay, anything wrong with you medically?
Please get it off.
Hey, right here. Hey.
This is off here. It hurts.
John. 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 Do you have any medical conditions?
I don't know why. I shouldn't even been off over here because I don't know why I went over here. Can you get this off here?
No.
This is over here on my arm. Look at that. Boom, boom, boom. Keep dropping me. All right, I'm gonna put a straw on your mouth. When I tell you to go, I need you to blow into this straw like you're trying to blow up a balloon. Hey, pay attention to me. I need you to blow in here like you're blowing up a balloon. You will keep blowing until I tell you to stop. I don't know why I'm blowing you off. Because I need to see if you need to go to the hospital or not. I don't know why. Ready? Take a deep breath in. Take a deep breath in and you're going to blow through the straw. No, it's not even tight. I'm not going to throw it out here. No.
Can you call for conference Walter ready at Walmart 615? Hey, come here. Look. Open your eyes. No, open your eyes. I want to look at your eyes. Open up.
Let's get this off, buddy.
No!
Come on.
Keep your hands down. Look at that.
Don't put that on there.
Open your eyes for her to see.
I want you to look at your eyes. I can really yell. I can jump at Congress. Can you tell?
A little bit on the outside. Yeah, a little bit.
Get this off. Come on, dude.
No. Hush it. I ain't taking it off. Leave it alone.
Come on.
Nope.
Or we'll take a sugar.
Odds are good. You might end up ready to mow the lawns, but just 'cause this is weird. I mean, so yeah, it could just be drunk. Possible, but yeah, this could also be medical.
What's your name?
I just went some
What's your name?
ball things over there. And
What's your name?
I don't know why I'm doing all this down. Hey, where's my truck? Please get this off here, please.
Sit down.
I'm not going anywhere. Please get this off. Please. Don't hurt me off.
Sit down. Sit down. You leave that alone. Don't touch it. Leave it alone. Take your hand and put it over here. Yeah, well, you shouldn't have tried turning your hand inside of it. I'll tell you what, we'll do that instead. There you go. Is that more comfortable? Okay, no problem.
Hey, take me down here. My wife is here. Oh, thank you.
I'm gonna take it off for you. Put your hand in there.
I'm not doing nothing bad.
Well, because you're in jail. And that's what happens in jail.
After everything they've experienced here, trying the PVT, trying to communicate with them, they're realizing this is something medical. The jail guard says to Officer Godby as he's walking by, it could be his blood sugar levels.
Could be blood sugar too.
So then the nurse goes to check his blood sugar level.
I'm gonna check your sugar. Go here.
But as you'll see, that ain't it. And to give him credit, the jail guard did finally take Mr. Hardwick out of the painful handcuffs. But unfortunately, as you'll also see, Godby puts him back in the painful handcuffs to take him to the hospital.
I'm not doing all, I don't need anything. I was just gonna go back up.
Get some things from where?
I'm not taking anything.
I said, get some things from where? Where are you at?
I don't like it.
Where are you at? Where were you at? Who? Hey, where here? Listen. Hey, right here. Hey. Hello. Hey. Hello. Hey, listen.
take you back home, buddy. I don't know what you did.
I can't get.
I don't know what's wrong. It could be for the CBA, it could be. No, that's what worries me is I don't get a really strong smell.
My wife is in there.
So Mr. Hardwick was denied admission to the jail. Kindly, Officer Godby put the handcuffs back on Mr. Hardwick in the same way that was hurting him before. As you can see from the in-car footage, it was causing him pain.
Please put that on my front.
Back in the car.
These are hurting. Oh, goddamn.
Back in the car.
Oh, please, these are bad.
Back in the car.
Put these on my front.
I can't. Sit down.
Oh.
He's got to go to the hospital with you. You need to listen to him.
Please get this off.
He is trying to help you.
Oh,
Trust me, he doesn't want to have anything to do with you longer than he has to.
it hurts my arm. Oh, shit. Damn. Hey. Get these down, please. Come on. Put these on my front. Can I put these on the front, please? Come on. These are hurt. Oh, God damn it. These are bad. Oh, they're hurting. Oh, God damn. These things bad. Please, these on the front. Oh, shit, these are bad. Oh, God damn. It hurts.
He had no idea what was happening. He was scared.
Oh, it hurts. Where are you going? Go down there, damn it. Oh, please,
To put this in context, with everything that you have seen that took place at the jail, now watch the part 2 video of what happens when they arrive at the hospital. And the officers are still trying to gaslight everybody that this guy is just really drunk.
He was trying to shoplift alcohol from Walmart. We believe him to be intoxicated.
And then even after the wife, she shows up to the hospital and she explains his medical condition, these cops know that they had just beaten this guy up at Walmart. People saw it. It was on video, and they're trying to cover their asses. One of the officers is texting, I believe it's the assistant chief of police, and he's basically saying, I don't really believe that this guy has severe dementia. So they're just going to stick to the lie that he was intoxicated. Obtained via a FOIA request by his lawyer, the denial of admission form from the jail for Mr. Hardwick clearly states that he was denied at the jail due to illness requiring immediate attention, not for intoxication. And we can see why they were holding out on this last bit of body cam footage, because it completely blows out of the water all these lies that they've had to live with, claiming that he was arrested because he was intoxicated, that he was denied from the jail because he was intoxicated, and that he was taken to the hospital because he was intoxicated. Remember from the first video, the assistant prosecutor who was prosecuting this case because they pressed charges. These heroes were trying to get a criminal conviction on this elderly poor man with dementia. That takes a prosecutor. The assistant prosecutor on that case was pushing for a conviction. And this involved alcohol, which she should have known, and the cops certainly knew, was absolutely false. And that's how bullies are. They don't pick on hard targets. They pick on the most vulnerable among us. Why do they do this? It's simple. To cover their own asses. When cops beat somebody, what's the best defense for them? To get a conviction. That forecloses a lot of liability from a lawsuit. The one good thing about this incident is that it has allowed average Americans to see how our government treats people just in general involved in the criminal justice system. And most of these people, mind you, have not been convicted of anything. These are just situations where people have been arrested, and we have to rely on the veracity, on the credibility of police officers that conduct investigations and make arrests. But time and time again, cops are caught lying. And in this case, we have now caught these cops, or this cop, Godby in particular, in a lie, caught red-handed. People have seen the footage and they're outraged, not just in that community, but across the country and even across the world. This is unacceptable behavior for a government towards its own citizens, especially in an allegedly free country. There is a petition to fire Officer Godby and discipline the other officers involved. It's now over 23,000 signatures. If you want to sign that petition, I will link it in the first pinned comment below, along with links to everything else, including the prior videos. And I almost forgot, there was actually a third video that I did about Officer Godby showing another dementia patient being abused by him and treated as being intoxicated when he was obviously suffering from severe dementia.
All right, if you would take a big deep breath and blow out for me.
Yeah, they're coming.
Blow out. Keep going, keep going. Hold on.
In fact, we're gonna catch that one right after this video finish. But you know, it's crazy that they keep hiring people like this.
I'll tell you more when we get off camera.
Think about that. The same officer doing what you see here to another elderly dementia patient. He's still there. He still has a badge. He still has a gun. What's worse, Godby himself and his behavior, or the fact that there are supervisors and mayors and a city council and other police officers enabling that to have happened? And if it's happened at least twice, what's the likelihood that it will happen to somebody else? If you want to help, the best thing that you can do is to continue to spread this footage and these facts in that petition. And I'll continue to follow as well. So you can follow along by subscribing both here and at the blog at the Civil.
Yeah, if you haven't already, go ahead and subscribe to the Civil Rights Lawyer. Like I said, this is a channel that I'm actually a fan of. And I don't say that often. But some channels I watch, you know, some of the content on there sometimes. But the Civil Rights Lawyer is a channel that I'm actually a fan of. Well, so again, this is them doing it again.
I've seen all I need to see.
I'll tell you more when we get off camera.
Does this police officer look familiar to you?
All right, if you would take a big deep breath and blow out for me.
Yeah, they're coming.
Blow out.
They just keep hiring these sickos. Like, these are sick people. They're really psychopaths. And they keep giving these psychopaths guns and badges to hurt people. Like, these aren't regular people. These aren't humans. These are people that are subhuman and act like animals or psychopaths. The way that they even conduct themselves seems like this is what a psychopath or a serial killer would do.
Keep going, keep going. Hold on.
That's Officer TJ Godby of the Danville Police Department, who I just featured for beating up and arresting an elderly dementia patient.
I'm not taking these off of you till you get into outside the jail.
What's your name? Godby.
Please get it off. It hurts. It hurts my fingers.
Well, what were the chances that this was not his first time in arresting and beating an elderly dementia patient?
When you hear a phone call that your dad got beat up by cops and you see pictures afterwards and the cop admitted to you, I called him, Phoenix Police Department. They connected with Mr. Officer Gobby, and he confirmed that he did use force because he thought my dad was on drink or on drugs.
That jail ain't gonna take him. Not with all them injuries and all that blood. He's 10-15 in custody.
Stand up. Stand up. Sit up. What is your problem, man? How much you
10-4.
Yeah.
On September 23rd of 2021, William Good was driving to work at the Bluegrass Stockyards at around 1:30 in the morning when he was pulled over by Officer TJ Godby, who was then with the Stanford Police Department. Like the last person I showed you that Officer Godby beat up, Mr. Good had been diagnosed with Alzheimer's. He had dementia at the time that this occurred. Godby was not wearing a body cam at the time, but this footage was obtained from the Danville Police Department, where he later worked when he arrested and beat up the other guy with dementia. And their body cam footage from the time shows some of what happened here. According to the Stanford Police Department citizen complaint that was filed by this man's son, Bill Good, his father, William Good, was apparently seen driving recklessly in the wrong lane. Officer Godby conducted a traffic stop, or attempted to, but Mr. Good, having dementia, failed to stop his vehicle, and he went on to drive another 6.6 miles. That turned into a low-speed pursuit. Heading towards Boyle County, Kentucky, Good was driving at about the speed of 40 miles per hour. Law enforcement eventually contained Mr. Good's vehicle, forcing him to stop. Good was then commanded to step out of the vehicle, and he did step out. Once out of the vehicle, according to the reports, Good and Officer Godby exchanged some words, and then Good reached back to the vehicle to get his license. They asked for his ID. Well, he went and got back into his car, and that's when all heck broke loose, explains his son Bill. The complaint reads that Officer Godby and a Lincoln County Sheriff's deputy pulled Good back from his vehicle. Good then tensed up and resisted the officers. This prompted Godby to deliver 2 knee strikes to his thigh. Godby and several other officers took him to the ground, where officers attempted to put Good's hands behind his back, but Good refused. Officer Godby then delivered 1 cycle from his taser in drive stun mode and handcuffed Good.
Can you sit up? Yeah. There, sit up for me.
That or drunk. Is everyone all right?
Yeah. Why didn't you pull over? Huh? Why didn't you pull over? The blue lights and sirens for 15 minutes? Did you notice you was on the wrong side of a U.S. highway? You're from Lincoln County. Yep. So you know this road? Yep. Yep. Nothing look odd to you? No. Nothing look odd to you?
Their report explains that Mr. Good sustained scrapes, scratches, and abrasions from the asphalt and was evaluated by the Boyle County EMS. But in photos provided to Lex 18 News by the man's son, his father is pictured with much worse injuries, with black and blue bruises all over his face and his body, and with a bandage on his arm and several cuts covering his face, hands, and arms. Bill says that his dad was not on drugs or under the influence. A breathalyzer test was conducted at the scene. We can see that on body cam, and it indicated that William's blood alcohol content was 0.
All right, if you would take a big deep breath and blow out for me.
Yeah, they're coming.
Blow out. Keep going, keep going. Hold on. It's gonna be like blow up balloon if you'll do it. All right. 2 seconds for reset. Big breath and blow out. Blow, 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 blow. All right. Hold on. We're gonna try this one more time. All right.
Negative.
Deep breath, blow out. Blow, blow, not suck, blow. All right.
Are you a diabetic? What kind of medical history do you have? No high blood pressure? No? Never had a heart attack? Never had a stroke? Anything like that? You take any medicine? What's wrong with your heart? Nitro? Okay. Are you allergic to any medicine?
In the body cam footage, the Danville police officers are heard discussing this incident, confirming that the BAC was 0.
We know, Mo. Yeah, I mean, he blew 0. Heels don't look like real. They're a little bit constricted, but
They also acknowledge that Mr. Good has some pretty good injuries and that they had never worked with Officer Godby before, at least not yet.
They do all this high energy stuff, and then they just stand around and don't work it. Like they're not doing anything. That's why we don't get involved in stuff like this most of the time.
Oh, I see that now. This is my first interaction with them. Blew all 0. His pupils look pretty normal.
He's got some pretty good injuries.
I'm glad to see an officer.
Or when they ended like that.
No.
Deal with EMS when it's well, he's pretty old. Yeah. That jail ain't gonna take him. Not with all them injuries and all that blood. Yeah, getting cleared. I told them to do it earlier and they didn't do it.
There still has not been a surgical call down.
Little did they know at the time that he'd be jumping departments and coming to work with them later so that their department also can participate in beating up and arresting an elderly man with dementia.
No, as soon as he gets loaded, we'll go back to our cruisers and someone can wait on this, not us.
Yeah, that's right. I like it. I don't want to be involved with that. I've seen all I need to see.
I'll tell you more when we get off camera.
Did you hear that? I'll tell you more when we get off camera. By the way, that was Officer Wentz with the Danville Police Department. Apparently, the investigation about this particular matter was closed on November 8th of 2021, and Officer Godby's use of force was found, quote, not unreasonable or excessive in his response to resistance displayed by Good. While there was a citizen complaint, it was found to be unfounded. Then, surprise, surprise, what happens when there's no accountability for beating up and arresting somebody who has dementia? It happens again. Godby gets hired by the Danville Police Department, and that's the same police department where these Danville officers are standing around talking about how terrible Godby's then department is. They really can't even believe what they've witnessed Godby do. What are the chances that this same guy does this twice? It's not like lightning struck twice here. Older people get dementia. This guy's just so dumb that he thinks anybody displaying symptoms like that, well, they must be intoxicated. To him, everything's a nail and he's the hammer. His power to beat up people and arrest them, that is the solution to everything to him. In my last video on this, I mentioned that there was this petition demanding the termination of Officer Godby and the suspension of the other officers involved in the incident involving Mr. Hardwick. And last time I looked and when I signed, it was somewhere around 4,000 or 5,000. As of right now, it's at over 20,000 verified signatures on the petition demanding the termination of Officer Godby. And now we find out that he had done it before. So if you haven't signed the petition yet, I'll link it below. And if you want to help, the best thing that you can do right now, other than signing this petition, is sharing this footage and keeping the word out there that not only did they do this to Mr. Hardwick, but the same officer did it to Mr. Good several years earlier. If there's no accountability for this, if nothing is done, it's going to happen again. And it could happen to somebody in your family. I'll continue to follow this one. And if you want to follow along, subscribe both here and at the blog.
All right, so here's another video of them abusing a elderly person with dementia. There's another one. Hold on, I got it pulled up. This is another one. So video after video of them just abusing the elderly with, not only are they abusing the elderly, they're abusing the elderly that have dementia or mental issues. It's sick. Really, I think cops are the ones who have the true mental issue. I wouldn't even, they're the ones. It's crazy.
Walmart, we believe him to be intoxicated. Wife says he also may have some dementia.
What's your name? God, but please get it off. It hurts. It hurts my fingers.
Almost a week ago, I posted a video about the 66-year-old dementia patient who was falsely arrested at Walmart in Danville, Kentucky.
He hasn't stolen anything, but he did walk in the back behind the customer service desk and grab these off the shelf. And he keeps
Sounds like enough for shoplifting for me. You just put your hands behind your back, just like we asked. Let's get this off. It's simple.
And then
This isn't another one. This is the update of the one we just watched before the last one.
Prosecuted before his lawyer got involved and got the charges dropped and their cover-up exposed. I have some updates for you. There was a city council meeting. The mayor spoke about it. The chief of police spoke about it. And now I've received a ton of new information from his lawyer, including the body cam footage of everything that happened at the hospital.
Figure out that he shoplifted, so at that point we take him into custody.
He wasn't actually shoplifting.
When that gets to court, they'll probably dismiss it all and you'll never hear anything. She's like, so I have to take him to court where he's not even under. Yeah, sorry.
Everything just looks so much worse. Spoiler alert, the mayor doesn't care. The chief doesn't care. The only ones who are going to care, that's us.
Well, last night, the Danville mayor publicly commented on the situation for the first time.
The Danville Police Department consists of both highly trained and certified officers. We, the commission, and I have confidence in and rely on that training. This incident is complicated, and a full understanding goes beyond sound bites and short video snippets.
You can either go up here and we can figure it out, or I can take you to jail. Choice is yours.
Put that on here. Let me go.
You're under arrest.
That's why I said no.
Yeah, absolutely.
I'm not taking these off you until you get outside the jail.
It hurts. Do you want me to put you in there, or do you want to get in there yourself?
And we will work to preserve and enhance the community's trust placed in the Danville Police Department. Our regular training and certifications reinforce the appropriate tools and tactics to protect our citizens.
Does it not count as their custody if he's in their chair?
Yes.
Welcome back to the channel. Out of the hundreds of videos that I've done, this one sort of got to me more than any other that I can recall. Many of us have had family members with dementia, and how awful was it to watch these police officers and these Walmart employees abuse this poor man. He was confused. He was attempting to follow their directions. He never attempted to leave the store, never attempted to steal anything, yet they arrested him. They violently abused him. They knew his wife was there, and they took him without even talking to his wife. And apparently what happened afterwards is they took him to the jail. We now know that the jail put him in a restraint chair and then decided that they would not accept him. So he had to be taken to the hospital to be medically cleared. And the new body cam footage that we have picks up there with these two officers, Godby and Ray, They still have Mr. Hardwick in handcuffs. He's still complaining that he's in pain from the handcuffs. The common theme that you see here is that they care nothing for this man. All they care about is themselves. Here, the officers are debating whether or not he should even be in their custody because the jail already took him and put him in some sort of torture chair. At this point, everything you see now, they've been told that this man has severe dementia. And you'll see that not only do they not care, they don't even believe it. They want so bad to believe that this is just a regular guy who is intoxicated, which would justify their actions, as opposed to the truth.
Well, and they can't refuse just because he won't blow into a PBT. Like, that's not... We've had that fight with them forever. Like,
well, he's also in the chair.
Yeah, once we take handcuffs off, he's not in our custody anymore.
What's your name? God, but please get it off. It hurts. It hurts my fingers. Oh, golly, it hurts.
And by the way, that is Officer TJ Godby. That is the same police officer who was caught on video punching this man with dementia 6 times. Now, they lied about it before. They've lied about it since. But you can see it on the video. He punched him 6 times. The community has created a petition calling for Officer Godby to be fired. As of right now, it has 6,719 signatures. I signed, and if you think he should be fired, go sign that petition. Or keep watching and see what else Godby does, and then maybe you'll want to sign it.
Let's get these off. Oh, it hurts my fingers bad. It hurts. It hurts. It hurts bad. It's gonna cut me. You can get this off because there's no reason I'm doing this right now. This would be better if I could get this in the front. Please get this off. It hurts. Golly, it hurts.
The hallway bit.
This hospital is packed and there's no room for him. So they basically just send him to a bed in the hallway. From the very moment that Mr. Hardwick was placed in handcuffs, he's been complaining to them that it hurts him. Finally, Officer Godby agrees to undo them and re-handcuff him in the front where it would be more comfortable for him. Hours later.
Have you said that? Please get that on. I'll put them up front for you.
Oh, I'm sorry.
Oh, that's crazy. Oh, look at that. You keep spinning your hand. Please.
Yep, we've got to put them back on.
Oh, it hurts. Golly, look at that.
As they're waiting for him to be seen, Officer Ray takes out his cell phone and he begins to text. I'm not sure exactly who he's texting. As you know, my eyes are not the best. In any event, he's texting with some other cop, probably a supervisor, about the situation. I took several screenshots of the text as this is happening, and the most fascinating of those is the revelation that Officer Ray is texting this likely supervisor and telling him that, yeah, he's confused, but he doesn't really buy the act. Shockingly, he was wrong.
All right, bud. My name's Joey. I'm one of the nurses here. Exercises back. There's only some vitals on you, okay, bud? Are you hurting anywhere? I don't need anything. I understand that, sir, but I need a few things from you. Heart rate, blood pressure, temp. Is that okay?
I need to take these off my knee.
Yeah, I'm sure you do, sir. But for right now, it does have to stay on. Are you hurting anywhere or anything? Put this on your finger. It's not going to be there long. So I'm going to take that as no. You're not having any pain, no complaints right now.
Did you know the picture?
Put this on the arm over here. We're going to feel your arm, okay? Make sure you don't have anything.
We're going to do EKG. Huh? We're going to do EKG. You know what that is?
Just a sec. Yes, sir. I'll get that off here in just a sec.
It goes inside the hour.
All right, it's gonna squeeze you, okay, sir? So we get a tip on you right here underneath your tongue. It just goes underneath your tongue. It's a tip probe. All right, bud. Sir, do you know how tall you are? Do you know how tall you are?
I'm fine.
How much do you weigh, sir?
I don't know where you get all this. I'm fine.
How much do you weigh, sir?
I'm just fine.
Okay. All right, I'm gonna take all this stuff off as you asked. Just hang tight. Doctor will be able to see you here shortly, okay? If there ain't nothing going on, you tell him the same thing you told me. We'll get you out of here with you split, okay?
Okay.
You got contact
Loss prevention at Walmart spoke to wife on scene.
Okay.
She was en route to the jail, and then we got refused at the jail right here. So
hang tight.
Wait, why is he there again? Supposedly this guy's intoxicated, right? The jail won't even accept him. What have we not heard mentioned? Alcohol, intoxication, doesn't even come up. Nobody mentions it. Nobody mentions smelling it. He doesn't appear to be intoxicated. They're just checking his vitals. Clearly, Mr. Hardwick doesn't know why he's there.
Looking stuff to buy something and y'all went crazy.
You just nurse.
I know y'all were wanting, but nothing's wrong with me then.
Hello there. Last name Hardwick.
One of the text messages that I was able to screenshot where they're discussing that Officer Ray is skeptical that this man has severe dementia. Officer Ray writes, well, he remembers us, quote, going crazy.
Looking stuff to buy something and y'all went crazy.
Well, you know, I bet that is one thing that dementia patients do remember. If they get beat up by a gang of police officers, punched 6 times, yeah, they remember that.
We are going to get an EKG on you. Is that okay?
I'm fine. I don't need anything.
Feel it, Maria.
he was trying to shoplift alcohol from Walmart.
Like I said, none of the medical personnel have mentioned alcohol. They're just checking his vitals. So Officer Ray then injects his opinion that he believes this man to be intoxicated. And, oh, yeah, he says he might have dementia.
We believe him to be intoxicated. Wife says he also may have some dementia.
What's your birthday, sir?
I don't need anything.
I understand, but you have to answer my questions to refuse. What's your birthday?
There's nothing wrong with me.
Sir, I need you to tell me your birthday.
Nothing.
Okay, then we're going to do the EKG on you if you can't answer my questions because I can't say you're medically cleared to refuse.
I don't understand the me why I'm off.
Okay, well, we're going to do an EKG on you. She's going to put stickers on your chest. Let me set this bed up for you. If you don't mind to swing your legs up there for me.
Lay back here. Lay back. Lay back here.
Yep, put your back there and put your legs up here.
Yeah, just like that.
There you go.
Yeah.
Yes, sir.
We're going to lift up your shirt so we can put the stickers on it, okay? These are you guys discharged. I got to well, we got to put these stickers on. He doesn't know what. I found out you were here.
Now Mr. Hardwick's wife arrives. Officer Ray then tells Godby that he's going to follow her and speak with her about what had transpired at Walmart.
Stand still.
You'll have to come over. I'm going to walk out and speak with her.
I've already been over there.
You gotta go through there. You can't come through there.
I can't be with my husband.
Not through these doors, hon. They gotta let you back there.
Where? What is it?
Hello, I'm Sergeant Ray. I'm one of the supervisors. I kind of fill you in a little bit what's going on. So we were at Walmart for an unrelated situation.
I saw you all.
Yeah.
Pulled in.
As we were leaving, one of the Walmart associates ran out to us, said, "Hey, can you help loss prevention with something real quick?" Asset protection. They're mystery shoppers, I guess is what people call them. So your husband was right there by the entrance. He had a cart with some groceries, some snacks, food, teas, and things like that.
Milk and muffins, and this is normal routine of what he gets.
And 2 cases of beer.
And his beer.
So they didn't feel comfortable serving him the beer for whatever reason.
Because he can't understand words.
So he's at customer service, so they take the beer and they walk it around back where they put all the returns. He then gets frustrated, walks behind the cash registers, behind the back, grabs the beer, starts to walk off. That's when loss prevention stops him. We get him to go back to customer service so we can try to figure out what's going on. Figure out that he shoplifted. So at that point, we take him into custody.
He wasn't actually shoplifting. Surely. He didn't walk out the door with the beer. He just wanted to buy his beer. I guarantee you wasn't shoplifting.
Listen to me. He walked behind a cash register where he's not supposed to be and was by the doors.
Oh, he went to the doors?
When loss prevention, so right there by the self-checkout, the main grocery entrance, not the pharmacy entrance, the main grocery entrance.
Okay.
When you walk in and make a left, like you're going to walk across the front of the store, there's a bench there.
Yes, that's where he sits, at least for me.
Yeah.
It's right in front of where he checks. Well, he doesn't check out there.
Yeah.
He just goes to a cashier because he can't understand.
Right. So he was walking out past that bench when loss prevention stopped him.
Surprised.
This is what Sergeant Ray said. He was walking past that bench when loss protection stopped him. That is false. First of all, here's the bench that he's talking about. When Officer Ray first walks up to the scene, the loss protection guy has the boxes of Bud Light sitting on that bench. There's actually 2 benches there. The loss protection guy who works for Walmart told Officer Ray where he was standing right then and there, right next to those benches, was not past the point of sale. Quote, he had not stolen anything yet. That is what Walmart told Sergeant Ray.
I'm with the Danville Police Department. We're going to go up here.
Come on. Okay, all right.
He's passed all points of sale.
He hasn't passed any yet. He hasn't stolen anything, but he did walk in the back behind the customer service desk and grab these off the shelf. See, and he
sounds like enough for shoplifting for me. So you can either go up here, we can figure out, or I can take you to jail. Choice is yours.
Put that on here. Let me go.
And in fact, he was only standing there because the Walmart employee asked Mr. Hardwick to follow him to that spot. Mr. Hardwick was not headed to that spot at all. What Officer Ray is saying is false, and the asset protection guy did not even tell him that. In fact, he told him that he had not stolen anything yet. He had not passed yet the point of sale.
He's passed all points of sale.
He hasn't passed any yet. He hasn't stolen anything, but he did walk in the back behind the customer service desk and grab these off the shelf.
Those benches were not past the point of sale. You can sit on those benches in a Walmart with something that you have not paid for yet. It is not a crime.
So,
I mean, no, it doesn't harm. Anything could happen with LTD.
Right. So then, when we try to take him into custody, he kind of, I want to say fought with us, but he was not real happy with us, which that's kind of where we're at. And then I spoke to loss prevention because I believe or you had spoke to him.
I did. He's Alex. He's a really nice guy.
Yeah. So I didn't know if you were still there with him or what was going on. And then we got him out to the jail, and the jail refused him because of his erratic behaviors. So that's why we're here.
Wait, why are we here again? Let's look to the police report. Godby then transported Hardwick to the Boyle County Detention Center. While at the Boyle County Detention Center, jail staff stated they could detect the odor of alcoholic beverage coming from Mr. Hardwick's person. Hardwick refused a PBT, a breath alcohol test, and was refused by jail staff. He made it all about alcohol in the report.
We got him out to the jail, and the jail refused him because of his erratic behaviors.
And is there any discussion with Mr. Hardwick's wife about alcohol, about her husband being intoxicated at Walmart? Not a bit of discussion. You haven't heard any, you won't hear any. But what else did he write in the report? Officer Godby transported Hardwick to the Ephraim McDowell Regional Medical Center for medical clearance. While at the hospital, Hardwick's wife arrived and spoke with the doctor. Hardwick's wife stated Hardwick is a binge drinker and that she should have been with Hardwick while they were inside of Walmart. That is what made it into the report out of this conversation. In other words, none of the relevant actual truth made it into the report. Lies alleging alcohol intoxication made it into the report, none of which you've seen on this body cam.
So,
is he going to be arrested? I mean, what's actually
we probably won't take him to jail. We will probably still go ahead and cite him just because of the totality of the circumstances. Now, when that gets to court, they'll probably dismiss it all, and you'll never hear anything else.
He has to go to court and can't even comprehend what he's going to court for. I may not even be able to get in there. You may have to come to the house and get in.
I understand.
I want to go to see a doctor now. I have to go.
I understand. And you will be able to, I'm sure you can make arrangements, with the courts, and we will let them know also what's going on and that we spoke to you and his medical conditions and that sort of thing, and they can work something out with you, okay?
So how crazy is this? Sergeant Ray says one thing to his wife, not making allegations that he was drunk at Walmart. They're both on the same page, right? About him having severe dementia. But behind the scenes, Ray is scheming about how he can successfully prosecute her husband for being this drunk guy shoplifting in Walmart in order to cover his own ass and his buddy's ass because they just falsely arrested and beat up this man with severe dementia. So looking back at the report, everyone's on the same page, right? This guy has dementia. They're literally at the hospital. And as you'll see, they're forced to release him with his wife. Everybody's on board with that. Then they go write up the report. Is there any mention of dementia in this report? No. He had an odor of alcoholic beverage coming from him. He refused the PBT, and so the jail staff refused him. Then while at the hospital, the wife arrived, and the wife said that he's just a binge drinker. Her fault. She should have been with him while they were inside of Walmart because, of course, he's a binge drinker. That's it. And then it just says Hardwick was cited to court due to unrelated medical issues. Unrelated medical issues. They did everything they could not to mention anything about the dementia. And then the last line says it was an unrelated medical issue. And when the officer's trying to explain himself, again, they put one thing in the report and they say another thing to your face.
So wife's down here at the hospital. She's saying that he has an LTD. I don't know what that means, but I'm sure it's, she says that it's progressively gotten a little bit worse. She lets him go to Walmart because that's one of the few places that he'll actually go now. We're fine with releasing him to her, talking to her, seeing him a little bit more. There may be something cognitively going on, but the way he was acting on scene and that sort of stuff. Yeah, just so. It is. It's really sad, and she said that Walmart's one of the few places that he'll still go, which he won't go there anymore after what.
He's sort of apologizing at the end, and he's saying, "Well, we didn't know about the dementia. Sorry, we're going to help you in any way we can. Had we only known."
We try to help you all out a little bit, but our hands were also kind of tied in the situation. We hate it. We don't want to have to do those types of things, but we also didn't know. But I will let our dispatch know. It will go in our system that way. If anybody in Boyle County runs him, it will come back that he has dementia. Yeah, and I will also get your name and phone number and attach it there.
Good.
That way they can call you.
Thank you.
Okay.
Thank you.
You're very welcome. No, it's okay. I mean, this is all things no one tells you, about. So unfortunately, it takes an event like this to get stuff rolling. So I've talked to the doctor. She's going to try to get you all processed and get you out of here. Okay? All right. All right. If you need anything, please give me a call. Okay.
Then he goes and writes a report, and the dementia is relegated to one line at the bottom that says Hardwick was cited to court due to unrelated medical issues. This is some real 1984 stuff right here. And as I showed you at the beginning, the mayor and the police chief, they don't care, but they should care because it will happen again, just like it's happened before. I have the personnel files now for these police officers, and this is not the only incident that you should hear about. More on that in the subsequent video. So subscribe both here and at the blog at thecivilrightslawyer.com. And if what you've seen here in Mr. Hardwick's situation bothers you, you can go sign that petition demanding that Officer Godby be fired. You can also help by sharing this footage. Don't let them escape accountability by this just fading away. Make sure that everyone sees it. Our rights don't end where your fears begin. Freedom is scary. Deal with it.
All right, y'all. So we got another one for cops arresting a mom. So we're just gonna go ahead and get into it. But as y'all see, imagine your grandparent who might have dementia being treated like this. Actually, my grandmother had dementia, and I couldn't imagine this happening to her. How do you expect people to react to that? This would really push people over the edge. I couldn't imagine that happening to my grandma. And
How could police think I'm 26 if I have a 30-year-old child?
A Texas woman is hauled off to jail after getting off a cruise ship in Fort Lauderdale.
I guess just go home and I'll fly
There's
home
no
without
way
her.
I'm not going to go home without you. But it turns out this was a case of mistaken identity.
Incompetent police officers in Broward County, Florida, arrested this 50-year-old mother of 3 grown children on a completely different woman's arrest warrant.
Are you serious?
How did this happen, and why did she stay in jail for over 3 days?
It's for endangering a child.
I think you'll have the wrong person.
Endangering a child. My kids are grown. They're in college.
They're grown in
and 30
college
years
and moved
old.
away.
Tragically, Christmas morning, Jennifer woke up in jail. She wasn't given a chance to consult with an attorney, to review the warrant, the charges against her, or to speak to any judge. Fortunately, the Institute for Justice has taken up her case, filed a federal civil rights lawsuit.
And now she's suing the Broward Sheriff's Office and Broward County.
Police cannot overlook obvious evidence that they have the wrong person when making an arrest. 23 years younger, substantially shorter, had different color hair, different color eyes, different license, and different social security numbers.
But the cops are saying they did nothing wrong.
And no employee misconduct was found. The matter is now closed.
I mean, they were literally captured on video arresting the completely wrong person. How can they say they did nothing wrong? I'll tell you what happened and how you can help join this fight to hold this police department accountable. This is a nightmare story that any one of you could find yourselves in, that your mother, that your grandmother, that your daughter could find themselves in.
Definitely Christmas we won't forget.
Have you noticed that everything requires subscriptions these days? Your TV, your phone, your computer, hell, even your house. I recently bought a new house and I realized two things. One, I had no idea the vast amount of money that I was wasting on subscriptions I didn't even know that I had, much less use. And secondly, I was doing a terrible job of just monitoring my own credit for mistakes. And that's why now I'm using Rocket Money, which is the sponsor of today's video. It's a personal finance app that helps you manage subscriptions, lower bills, build a custom budget, and basically grow your savings all in one place. It safely and securely identifies any recurring charges that you have, and it cancels unwanted subscriptions for you with basically just a few taps. Rocket Money will alert you to any important changes that impact your credit score. So if you want to save more money and spend less, join the over 5 million members now using Rocket Money. And I've got the hookup. Go to rocketmoney.com/civil or click the link in the description below to get started for free. Thanks again to Rocket Money for sponsoring this video. Now let's get back into it. This is Jennifer Heath Box. She lives in Richmond, Texas with her husband, Kyle Box. She has 3 adult children and they're all out of the house. In January of 2022, her brother Mark was diagnosed with cancer for a second time. Once doctors confirmed that his treatment was successful and that he was fit to travel, Mark invited Jennifer and her husband, Kyle, on a cruise to celebrate his health and other milestones that had passed while he was in treatment. Jennifer was elated to have this time with her husband and her brother's family, after which she planned to promptly return home to Texas over the Christmas holidays so that she could spend that time with her children. It was going to be the last time for at least 3 years that she would have all of her children together because her son Joshua had just completed his training with the Marines and he was set to be deployed to Japan for 3 years, beginning December 27th. But unbeknownst to Jennifer, while she and her family were enjoying this celebratory cruise, the Broward County Sheriff's Office in Florida was planning to arrest her for someone else's crime. When Jennifer's cruise ship arrived back at Port Everglades, Florida, early on the morning of Christmas Eve, she and her family began to disembark. Several Broward Sheriff's Office officers, with the help of U.S. Customs and Border Patrol, were waiting to arrest her before she could even get off the ship.
When I was disembarking, I went and scanned my photo ID, and at that point in time, it just rang for security. And so they had me step aside. And then at that point in time, we noticed that police were coming on to surround me and my husband.
If we verify, are you serious? If we verify.
When Jennifer asked why she was being detained, deputies told her that it was for a warrant. She asked what the warrant was for. Broward Sheriff's Deputy Peraza responded that it was from Harris County, Texas, for endangering a child, specifically for endangering a dependent child under the age of 15.
I have no transportation.
We just told you it's for a warrant.
A warrant for what?
Yeah, could you do that?
It has to be verified still anyway.
So that's verified, but I mean,
So,
we're already at this point. It's for endangering a child.
Now, this didn't make sense because Jennifer had no minor children. She had never been arrested before. She's never had any real outstanding warrants. Her husband, Kyle, immediately said, "I think you have the wrong person."
I think you'll have the wrong person.
But Deputy Jean responded, "That's why we verify."
Endangering a child. Well, that's why we verify.
That's why we're going to verify it.
That's why we verify. It's okay.
But Deputy Peraza, as you'll see, he had already made up his mind to arrest Jennifer, stating, "We have to verify, but we're already at this point, so..."
So that's verified, but I mean, we're already at this point.
Deputy Peraza then asked Jennifer her age. She told him her date of birth, which was from the year 1974.
January 28, 74.
Jennifer telling Deputy Peraza her birth date should have been a giant red flag. The person he had the warrant for was somebody nearly half Jennifer's age. Jennifer handed officers her driver's license and also her passport, both of which contained plenty of information to alert the officers that they had the wrong person. As Jennifer pointed out to the officers, it was impossible that the warrant was for her because her children were grown and in college.
Endangering a child. What child did I endanger? You have a child? My kids are grown. They're in college.
They're grown in college and moved away.
I like I said, that's why we verify.
Is this something that's out of Florida? I know this is not right. You got 110%.
I don't know what's on it.
This is absolutely.
Go ahead and do what I just saw. What I had mentioned to you, give them everything. Don't have the phone. Hold on to the phone. So these are the only two things we're going to bring with us. Go ahead and give them the wallet, the purse. Don't take the jewelry off if you want. If you have any necklaces, earrings, go ahead and take that off your belt. Take that off.
Make sure you tell him where you put all the
My
valuables.
jewelry's all in here. Passport, I need this.
No, no.
Do you have any piercings?
No. I guess just go home and I'll fly
There's
home.
no way I'm not going to go home without you.
Where's home?
Texas, Houston.
To go see our kids.
That's where the warrant is out of. So you're going there.
I don't know what kid I endangered.
She has a necklace.
Just looking at Jennifer should have caused any reasonable officer on the scene to realize that she was not the person they were looking for. There were at least 5 observable differences between Jennifer and the woman that they were looking for. Jennifer was 48 years old, while the warrant sought someone who was 27 years old, nearly half Jennifer's age. Jennifer is 5 inches taller than the suspect. Jennifer has fair skin, while the warrant sought someone with medium-toned skin. Jennifer has light blue-gray eyes, while the warrant sought someone with brown eyes. Jennifer has red hair, while the warrant sought someone with black hair. There were all these discrepancies between the warrant they had and the information available in the National Crime Information Center database. The names were different. The warrant was for Jennifer Del Carmen Heath, while Jennifer's name is Jennifer Heath Box. The suspect's address was an apartment in Houston, Texas, while Jennifer's address was in a different county in Richmond, Texas. They both had different social security numbers. They had different FBI numbers. At the very least, all of these discrepancies would have caused any reasonable police officer to do their basic due diligence to confirm whether the person that they were about to arrest was actually the subject of the arrest warrant.
Definitely Christmas won't forget.
We're trying to make it as little as possible money, okay?
And I don't understand why this was Houston. Why didn't I get arrested when I was
Just do me a favor, check all the pockets right now. Just show that weight. Okay.
Go ahead, get rid of that.
Get rid of it. Check your back pocket, your front pocket, no little, anything small. Your earrings.
I don't have any earrings.
Like you're praying.
I was feeling everything from confusion to, frustration, anger, because I knew that this was impossible to have a warrant for child endangerment. And in my mind, all I kept thinking about was I need to get home to my son because he was leaving on the 27th. And this was Christmas Eve. And this was my last Christmas that I would have all my kids together.
Okay. Oh, you're good?
He told Jennifer that the birthday and the name on the warrant matched hers, but that wasn't true. The suspect's full name was Jennifer Del Carmen Heath, not Jennifer Heath Box.
It was Jennifer Edkin Box, B-O-X.
What's your middle name?
It's Heath, H-E-A-T-H.
The video footage shows that Deputy Peraza's actions go well beyond just incompetence. At one point, Deputy Peraza lied to Jennifer and told her that the information on the warrant matched her date of birth and her married name of Box. That was a lie. It did not.
With the same birthday? With the same AKA Box?
No, that's me.
Okay, well that's what we have on the warrant right now.
I'm just saying, I don't have, that's all, I'm just...
Peraza had also previously told the female deputy before he left, Deputy Jean, that he had, quote, confirmed that Jennifer was the subject of the warrant. In no way did Perez confirm anything.
The suspect was also 23 years younger, substantially shorter, had different color hair, different color eyes, different license, and different social security numbers. Despite that, Peraza still brought the wrong Jennifer to the police station.
I don't think that he was even really hearing me. And I just felt like the whole entire time I just didn't have a voice, you know, that it was just completely lost because in his mind he had.
This is insane. This is not just a mistake. Like, you can tell, like, you just have to be an idiot because nothing matched. The only thing that matched was the first name. That's it. Which is crazy because so many people have the same first name, but they don't have the same last name. They don't have the same hair color, eye color, height. It's crazy.
Had his agenda of why he's arresting me.
Was from July 20th, 2022.
Okay. I was just curious, like I said, 'cause I know I've gotten pulled over before since then in Houston, and I haven't heard anything. That's just why I'm just confused with all this. And I don't have a 16-year-old.
There's nothing about a 16-year-old in there.
All my kids are all grown, I guess is my thing.
You've had no incidences at all whatsoever
Never.
in the past couple of years.
I promise you, I'm sure you hear this a lot. Never have.
How could police think I'm 26 if I have a 30-year-old child?
Ignoring every indication that he had arrested the wrong person, Deputy Peraza brought Jennifer into the booking station at the Broward County Jail. There, more red flags were ignored. When the BSO officers booked her into the jail, a female jail officer scanned Jennifer's driver's license and informed Deputy Peraza that there were no outstanding warrants attached to Jennifer's driver's license. And this backed up what Jennifer had told officers all along, that there was no warrant for her arrest, that they had the wrong person. But being representatives of government, the officers once again ignored evidence that was very clear that they had the wrong Jennifer. Unable to admit his mistake, Deputy Peraza convinced the female jail officer that she also should ignore these red flags and all the evidence indicating that there was no probable cause to have this person incarcerated in their jail. All Deputy Peraza had to support his mistaken claim that this was the right person was that Jennifer shared 2/3 of her name with the suspect, and it turned out the suspect's mugshot appeared to look like Jennifer. Then, unbelievably, Deputy Peraza filled out an affidavit in support of Jennifer's arrest, which means under oath, and on that form, Deputy Peraza listed Jennifer's correct identifying information, even though that correct information contradicted the description of the suspect, Jennifer Del Carmen Heath, who was wanted in Texas. So they booked Jennifer into the Broward County Jail anyways. And of course, they also took Jennifer's fingerprints and mugshot. And guess what? The fingerprints did not match, obviously. Jennifer endured a traumatic Christmas in jail.
It was dirty like you would imagine. And then the strip search, you know, it's just humiliating and degrading, you know. Sorry. I mean, it was just, sorry. It was really traumatizing, you know, and that part of it, you know, just because you just felt like you weren't a human anymore.
They made her strip all of her clothes and conducted a body cavity search. They gave her a prison uniform and a blanket and put her into a cell with other female inmates. The guards were condescending and demeaning anytime she asked a question. In her first night in jail, she witnessed a fight, continuous screaming, yelling, and violence. Guards kept the jail cells ridiculously cold, so cold that the guards wore heavy coats, hats, and gloves, while the inmates, including Jennifer, were given small blankets that were not nearly enough to stay warm. She was forced to shiver all night. Eventually, she laid back to back with a stranger just to try to keep warm. Tragically, Christmas morning, Jennifer woke up in jail. She wasn't given a chance to consult with an attorney, to review the warrant, the charges against her, or to speak to any judge. While in jail, Jennifer was permitted 2 phone calls a day, which she used to communicate with her husband, Kyle, who was keeping her up to date on his efforts and her brother's efforts to get her free. On the afternoon of December 26th, her husband told her that Harris County, Texas, acknowledged her DMV photo had been placed on the suspect's warrant. About an hour later, a jail official came to Jennifer's cell and told her that Broward Sheriff's Office knew she was not the person who was wanted in Harris County. For a split second, Jennifer thought this nightmare was finally over, but her hopes were quickly crushed. She was told that despite their mistake, the only way for her to go free was if Harris County officials came to get her or arrested the correct Jennifer Heath. She was told this could take up to 30 days, if they came at all. She was devastated. Broward Sheriff's Office continued then to hold Jennifer in custody for the remainder of December 26th into the morning of December 27th, even though they now knew that she should not have ever been detained in the first place. And as a result of that, she was forced to endure another night of cold, uncomfortable, traumatizing conditions. She was finally released from custody at 9:50 a.m. on the morning of December 27th, 2022, over 75 hours after her wrongful arrest. And by that time, it was already too late to celebrate Christmas with her children, and worst of all, too late to say goodbye to her son Joshua before he left for his deployment to Japan. To this day, nearly 2 years later, Jennifer still has not had all of her 3 children together as she would have. And to date, she has never received an apology or an explanation for why the Broward Sheriff's Office mistook her for Jennifer Del Carmen Heath. When she was released, Broward Sheriff's Office personnel simply told her, hey, it happens.
While I was in jail, I had missed out on Christmas Eve. I missed out on Christmas Day with my kids. I missed out on my family time together. I took my brother away from his family on Christmas because they spent their time trying to get me out of jail. I didn't get to see my son off to the airport for him to be stationed over to Japan for the U.S. Marines. I missed out on everything. I missed out on all my family time with my kids. I missed out on having those moments happen, photos and pictures and memories. I missed out on all the opportunities.
And Broward County remains defiant. They've maintained publicly that Deputy Peraza followed the department protocols when he arrested Jennifer in the face of overwhelming evidence that he had the wrong person. Broward Sheriff's Office Internal Affairs Division reviewed the incident and confirmed that the officers followed Broward Sheriff's Office protocols and did not violate any BSO policies or practices when they detained Jennifer for over 75 hours without even confirming that she was the correct person on the warrant.
BSO sent us a statement saying they sympathize with Mrs. Box. They also say, in part, had it not been for the arrest warrant filed by the Harris County Sheriff's Office, Custody Patrol would have not flagged Miss Box. BSO would have not been notified, and she would not have been arrested. They go on to say, the actions of the BSO deputy involved in arresting Ms. Box were reviewed by the Broward Sheriff's Office Internal Affairs Division, and no employee misconduct was found. The matter is now closed.
And isn't that just a shame that this entire unit of internal affairs for this large county in South Florida reviewed this entire thing and they were unable to find any misconduct there? Crazy, right? Well, don't worry, because Jennifer reached out to the Institute for Justice and they agreed to take her case. If you've watched a lot of my videos, then you know who the Institute for Justice is. I have my own custom donation link for them in the description of every video. But in case you don't know, IJ is a nonprofit public interest law firm. Their mission is to end widespread abuses of government power and to secure the constitutional rights that allow all Americans to pursue their dreams. It's a national civil liberties law firm that represents everyday people free of charge when the government violates their most important constitutional rights. They win nearly 3 out of every 4 cases that they file, despite how incredibly difficult it is to litigate against our government. They very kindly put together this document called a complaint, also known as a federal civil rights lawsuit, that explains in great detail over dozens and dozens and dozens of pages exactly what misconduct occurred, who did it, when they did it, how they did it, the evidence that exists that they did it, and that also lays out why that misconduct violated Jennifer's constitutional rights. This is IJ lawyer Jared McClain, who is handling Jennifer's case.
Holding someone in jail without a good reason to believe that they've committed a crime violates the Fourth Amendment and the right to due process. Police cannot overlook obvious evidence that they have the wrong person when making an arrest. And when they do, they must be held accountable.
I just have to hold those accountable for what they did, but also to get justice.
And basically, the law is as simple as that. While a warrant to arrest somebody is a judicial determination that there's probable cause to arrest the subject of the warrant, a warrant for one person does not give probable cause to police to arrest some other person, even with a similar sounding name. When officers have reason to believe that the person that they plan to arrest is not the actual subject of the arrest warrant that they plan to execute, they must either stop and confirm that this is the correct person, or they have to abandon the arrest. BSO officers here should have realized that there was no warrant for the arrest of this Jennifer, and they should have done that before ever even confronting her and detaining her in December of 2022. All the information that the officers needed to verify that she was a different person was readily available. All of these discrepancies that we discussed already would have caused any reasonable officer to then do some basic due diligence to confirm that this is actually the right person. There's overwhelming evidence here that every government employee involved in this acted unreasonably. At best, at worst, once they found out that this was the wrong person, they ignored the truth to cover their own asses. It's fantastic that the IJ has taken up Jennifer's case, but they are a nonprofit law firm. They rely on donations. The government has a never-ending supply of your money, gaslight the public, and pretend like they did nothing wrong. Whereas the IJ is funded by people from this audience, by patriots from across the country, by individual citizens who feel strongly about the fight to protect our constitutional rights. This audience has raised a lot of money for the IJ in the past, and this case is a worthy cause to continue doing that. This is a nightmare story that any one of you could find yourselves in, that your mother, that your grandmother, that your daughter could find themselves in. You can help right now to fund this litigation, to keep these IJ lawyers working around the clock to sue every government employee that was involved in this case, from Deputy Peraza all the way down to the Jane Doe jail guards that we don't even know their names yet. It's all going to take litigation, lawyers, paralegals, filing fees, depositions. It costs a lot of money to do this. Let's fill their war chest to help ensure that they win. And I'll continue following this one. And if you want to follow along, please subscribe both here and at the blog at thecivilrightslawyer.com. Our rights don't end where your fear begins. Freedom is scary. Deal with it.
All right, y'all. So I'm gonna go ahead and end the stream on that one. We've been here for a while, and it's never ending, you know, which is, it's sad to say, but it's never ending. And we gotta keep getting this content out there, because a lot of people think or don't know that, you know, every time that you deal with the police, you're at risk. It's, you know, you might be hurt, or they could take you to jail for whatever reason they decide or they feel like. You know, it's not because you actually committed a crime, because you don't have to be a criminal and they will still take you to jail, which is crazy. So you don't have to be a criminal, they will take you to jail. You don't have to, you can literally be exercising your rights and they'll take you to jail. You know. But it's crazy. So, but with that being said, AWB, I'm out. I'll catch y'all on the next one. Oh, yeah, but the reason I spent so much time on the Civil Rights Lawyers channel is because I'm actually a fan of this channel. Actually, I learned a lot from just watching this channel and going about exercising my rights. You know, which I don't say often, because I don't really like, I wasn't really a fan of other channels or other, I guess, First Amendment auditors. It's just a few that I, would say I'm a fan of. But yeah, with that being said, it'll be I'm out.